Okay, here we go.
Stuck at the fucking case. It's going down. Shout out to Law on Crime Network.
All right, so
this is covered under the Fair Use Act.
The proposed order. I need to get that list off of the proposed order and into some format that works well for this. You know what I'm saying? Let me show you. He sent us over.
This joint is serious.
Friday. I did. I changed the orders.
This joint is serious.
But
serious.
All right, here, this. So look at that. And see how he did this right here. This is all that I was trying to change. Oh, I'm going to attach here to as Exhibit A. Okay. See, this is how I did. No, I got it. I know what to do. This is it. Attached here to this Exhibit A.
Nigga in the courtroom texting.
All right, we have it. We're almost there.
How the fuck they doing all that? How the fuck is he doing all that though?
Persons listed.
Really texting.
Exhibit A attached here to shall be subject to it. All persons. Okay, I got it.
I don't know how the fuck in a courtroom with a cell phone?
Okay, all right.
Texting.
I'm going to share this document, Your Honor, with the court and the parties.
The email?
Yes, Judge.
All right.
We gotta free this guy. This trial been going on for too long, yeah. This trial been going on too long. This don't even look like no courtroom now.
Yeah, I know. Yeah, I can't. It was in December.
Did you send it already, Ms. Love?
I had a hiccup and I'm sending it now.
This shit. I'm just sitting here thinking, like, how the fuck? Like, I don't know what's going on down there in Georgia, but they got all type of shit going on from last night, what I heard, to all this. Man, this shit. Man.
Okay, so what I've done is send it to everyone. I don't think I sent one to Ms. Weaver, but what I did to remedy the problem of waiting for our reformatting of that was say, the witnesses listed on Exhibit A are subject to the terms of this order. And that way you can go ahead and get the court signature on the order and attach the exhibit and send it over to legal counsel for the GBI and the GCIC.
Okay, what's on Exhibit A?
It is the witnesses that Mr. Steele has provided, minus things like custodian of records for Magic City or hers. Those are names that were listed. I was trying to go through and take that information out. But Exhibit A will consist entirely of the first 70 names that we provided as witnesses we intend to call in the first 3 weeks. And Exhibit A is important because I would like for them to get those criminal histories first.
Mr. Steele, is that agree with, what I want to do is I'll sign the order. You need to, I can print and sign right now, but you all need to pen and.
I think we're in agreement with the people,
They
the way that we're gonna do
They
it.
trying to
So,
roast my man.
Mr. Steele, any objection from you, sir? No, is that acceptable to you? Correct.
that is fast.
They trying to roast Thugger. I don't know what's going on, man. I just hope everything works out in that favor.
All right, Ms. Love, I'm going to hand this to you. Counselors, if you want to check it, or have some, Mr. Steele, if you want to check it, it bears your two signatures, that is Ms. Love and Mr. Steele, in regards to the court's signing that order. So you're going to attach Exhibit A to it?
Yes, and this
And when
way,
are you when are you going to scan that to council? You can file it. You can email it to whoever it is your point of contact. But I'd like you to file an order under seal.
that was what I was getting at. I had
Okay.
to prepare that.
Just make sure that sure that's Mr. Steele. But when are you planning on sending that to council for the GBI?
I'll email it before noon tomorrow, probably tonight.
Can you send the court a copy and the parties a copy when that is done?
Absolutely.
Will that be sufficient, Mr. Steele? Correct. What about anybody else? Is there anybody else who has any specific objection or concern or comment about that? Or is everyone in concurrence that would be a suitable resolution or plan for the GCICs and that we discussed earlier?
And so that council knows, I have included in the order that counsel for defendants currently on trial before this court are permitted to review and share, but only people who are currently on trial.
Okay.
For this court.
Yes, I anticipate getting the GCICs and then dispatching via email to the lawyers here.
Okay. All right. Okay. Unless there's anything else, I'll see everybody on Monday, the 27th.
We got to go back.
We need to be here and seated and ready to go so that we don't have to wait on our jurors to come. So make sure you're here about 8:30 or thereabouts and get situated and get settled. And we'll get everything started at that point in time for 9 o'clock. As soon as all of our 18 jurors are accounted for, we'll get started. All right.
You did say 9:30 though.
No, I said 8:30. You need to be here. We're starting at 9.
I heard it was 9:30.
Starting at 9, sir.
Just an approach before the court leaves, matter unrelated to.
Okay. All right. Unless there's anything else, happy Thanksgiving, everybody. Okay. Okay. All right. We're in recess.
Thank you.
This case is it's kind of weird. What's
Okay. All right, folks. So last thing we were talking about was the issue of the witness list.
So we have gotten that.
Yes, Ms. Lowe.
I just sent that to Mr. Steele, Your Honor, for his review. We just discussed it. He's okay with the closed order. We're gonna calculate it. In short, what the order is requiring GCIC to do is to provide within 72 hours the criminal history record information of the person's name in the order. We have on the original list given to us by Mr. Steele some, I believe, professional witnesses. I had asked one of our legal assistants to go through that list, take out professional witnesses, law enforcement officers, things of that nature, and to include on the list first the witnesses that we have provided last evening as the first 3 weeks worth of witnesses, and then in order based on our projected trial structure.
Okay. Can I get that in short order, like within the next 20 minutes?
I believe so. And I'll,
Because if you all could print it, I will sign it, and then one of you can e-file it, and it can be transmitted.
okay,
Okay?
yes. Yeah, and what I will do is also send it personally to the gentleman that gave me the directives in the first place,
All right. Okay.
so that it can be considered received by them.
Okay. All right. So we'll do that. Okay. Based upon the other issue that we had, just kind of make sure I have the notes.
brain's dead too. Okay. Sorry. I can't think. Miss Weaver, may I get one of your naproxen? Or two?
Absolutely.
I don't think you're supposed to exceed 4 in the day. I don't know how to react.
Welcome.
DC powder.
Scared.
She may be able to do this. Just tell her. Mhm. Thank you. And Your Honor, Mr. Steele has suggested, and I would ask the court to have this order filed under seal, considering it has identifying information.
I don't have any objections, Your Honor.
It can be filed under seal. Yeah, in fact, that probably preferred. So let me, if you'll, I'll sign the order. You can transmit it and we'll file it under seal. You'll need to give me a sealing order, Ms. Love. Just make sure you run that by Mr. Steele, okay?
Okay.
All right. council, what I was thinking about with your concurrence is, I'd like to, on the 1st of December, that's a Friday, after Thanksgiving, for you all to have met and for you to tell me, I'm going to inquire about it probably on Wednesday, the 29th of, but I'd like to by Friday for you all to have an actual schedule of, and that should give you the better part of now to set up appointments and schedules with those witnesses that you wish to go ahead and interview. So I'd like to see a schedule, either via Zoom or in person, it can be here at the courthouse.
You don't want to let this case up. They got to get him off the jump.
Or via Zoom.
They got to get him off the
Can
bench.
commence
That's the reason why I rewinded this track.
from the
They got to
18th
get this
of
judge off the
December
bench.
through the 29th of December. I'd like to see a proposed schedule for those particular witnesses. So that should give you some time for you to look at and consider which witnesses and contact them for their availability. Okay?
Yes, Your Honor.
Your Honor, that's fantastic. Thank you. Thank you very much.
All right.
You said
Also, if
18th.
this-
No, go ahead. I was just trying to make sure I got the dates right.
All right. So what I'd like y'all to do is to work between now and then, because I actually want to see a list and a schedule, just to make sure that we're good. And if I need to be available, or if I can make myself available. But it is my intent that week of the 18th of December to give our jurors some downtime to get prepared for the holidays. It is my intent to
They need to let
start back up
case go.
on Tuesday, January the 2nd. So we work about 3 weeks. And then we'll take that time, just do the scheduling and the holidays and everything else. But that should give you time to remedy that particular issue as it relates to any witnesses that otherwise have not been able to be resolved.
They don't want to let up.
May I speak, Your Honor?
Yes, if Mr. Harvey and Mr. Matthews, if I can,
I was just checking on the dates just to make sure, Judge, and I was
Yeah.
tired. It was whispering too loudly, I guess.
All right, sir. Everybody, there's enough time for everybody. Yes, sir.
And then if the state would be good enough, they gave us a list for the next couple of weeks. But if there are people that you can tell us who's coming the first week, because this way, the 18th is after, obviously, the first 3 weeks, so this way we can, or you have a court, you need to interview.
Okay,
Quick order.
I get what you're saying.
All right.
Thank you.
Okay, so I'm gonna expect to see like I said, a physical list on the first, and I was gonna tell you all on the first, it will be, I will.
They don't want to let up. Y'all can say what y'all want. He ain't trying to let up. He ain't trying to let up at all. Get him off the bench, y'all. You see it in Young Thug and them kids. Young Dove case. They gotta get him off the bench. They gotta get him off the bench. Yes, sir. We gotta get him off the bench.
Yes.
Bastard.
The physical list to the court on December the 1st.
Yeah, I want to see it so we can talk about it and you all can kind of just, that's just kind of a deadline so kind of as a forcing function, Ms. Love, so that I can,
Understood.
so you all have met before then and can give me a proposed schedule as to how many people you plan to talk to on any given day. And you can account for everybody so that, say for example, you have 20 witnesses or whatever else, where you're going to.
They know they got over 100 witnesses.
You've already talked to them and they're available these dates and these times via Zoom or in person. So as to make sure that there's no
misunderstanding.
There were no issues about, well, I thought that somebody was going to be available. So I want to see some times and some confirmation that you've talked to those particular people and they are going to make themselves available. Because one of the things is if they don't want to make themselves available, then I may need to go to another, make some other decisions. If appropriate, okay? All right. And you're welcome to use me as the reason as to why they have to make themselves available. So, all right. Any questions about that?
No, Your Honor.
All right. It's conceivable also on the 1st that we'll just have given some other things that the court has related to my other duties that we may have. Our jurors may not come in that day, but we'll have that thing to do, and then we'll break for the day, and then pick back up on the 4th, that following Monday. Okay, all right. Okay, let's talk about our 418 issues. Do we have some? I think that was the last thing I had that I needed to cover at this point in time.
It is, Judge, or at least it's one of the last.
Okay.
Judge, the state filed on October the 24th, 2022, state's motion and memorandum of law in support of the admission of gang-related evidence.
Get a petition in Barstow and get him off the bench.
Do you have a copy of that? Because I don't have my scribe. I don't have my assistant here today, Mr. Kearns. So.
If Brian Steele was smart, if Douglas was smart, they'd get this judge off the bench.
I've looked at it, but I just don't have a physical copy and I need to.
Man, you ain't trying to be part of it. You ain't look at nothing, bro. You ain't look at nothing. I'm talking about you looked at stuff that you're not going to agree. You're not going to grant motions.
For purposes, I am presenting to the court state's preliminary motion to introduce intrinsic evidence of criminal street gang activity filed November 30th, 2022. The state's motion and memorandum of law. Can you all hear me? Yes. In support of the admission of gang-related evidence at trial filed October 24, 2022.
That's last year, y'all.
The state's preliminary motion to introduce intrinsic evidence of criminal street gang activity and notice of intent to introduce the same filed November 6, 2020.
All right.
We're not granting no motions, y'all. Man, this judge a class, man. Allegedly.
All right, madam.
So, Your Honor, we filed on October the 24th of 2022, our motion and memorandum of law in support of the admission of gang-related evidence at trial. In our motion and brief, Your Honor, we specifically speak to the statutory authorization for the introduction of gang evidence. And those include the elements of proof in a gang act case. Said elements including that the group falls within a certain definition. That definition being that A criminal street gang is any organization,
More
association,
than
or
one.
group of 3 or more persons
Mhm.
associated in fact, whether formal or informal, which engages in criminal street gang activity as provided under Code Section 1615.3.2. And as such, proving the necessary elements of a criminal street gang requires that demonstrating that the group in question committed criminal gang activity. And the Gang Act then goes on to define criminal gang activity as
what?
comprising a catalog of offenses that are listed under 1615.3.1A1. One of those defined offenses is racketeering activity, just for the court's
Okay.
awareness as it relates specifically to count 1 in this indictment.
Okay.
As it pertains to an individual defendant, 24-4-418 mandates for the presumptive admission of that defendant's other acts of gang activity for any relevant purpose, Your Honor. And 1615.9 explicitly mandates that gang-related evidence shall be admissible to establish the existence of a criminal street gang and criminal street gang activity.
Like really
We have
is.
cited for the court the statutory authorization for the admission of that evidence. The third statutory provision that unequivocally authorizes the admission of gang-related evidence is OCGA 1615.3, which allows for certain specific types of evidence. And I am on page 6 of the motion that we filed at the top, Your Honor, in order to establish the existence of a criminal street gang. That provision of our code section states that the existence of the organization, association, or group of individuals associated in fact may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or other attire or other distinguishing characteristics, including but not limited to common customs or behaviors. And pursuant to these statutes, the existence of criminal gang activity and criminal street gangs can be proven through a variety of means, including law enforcement officer testimony and statements of criminal street gang members and associates. Your Honor, as we outline in Section C of our motion, legislative intent dictates the admission of gang-related evidence.
That's what
24-4-418, 1615.9, and 1615.3.2 echo the specific and statutorily enumerated intent behind the Gang Act, namely that the Gang Act's purpose is to eradicate the crisis of criminal street gangs that represents a clear and present danger to the state of Georgia. The seriousness with which the General Assembly has determined the state of crisis caused by criminal street gangs present in Georgia is reflected in the compulsory increases in bail and mandatory conditions of pretrial release that are required in cases involving criminal street gang activity, as we outline at the top of page 8. Further demonstrating the significance and gravity of offenses involving gang activity, OCGA 1761, Section 13 requires that superior courts exclusively hear bond hearings on Gang Act cases, and consistently 1615.4L, as in Lima, imposes mandatory sentence conditions, and OCGA 17610, Section 2 provides for extended periods of probation supervision for Gang Act violations.
They're trying to fry the niggas.
As the General Assembly has enacted specific statutes authorizing the admission of gang-related evidence, general objections with regard to that evidence, that is, relevance, prejudice, character, when introduced for the enumerated purposes, Your Honor, must fail.
They trying
And
to
gang-related evidence should
along.
accordingly be admitted at the trial of this case pursuant to 24-4-418,
They're allegedly fitting them acts. That's the
1615.9,
thing.
and 1615.3.2. Your Honor, the basis for admission of gang-related evidence generally and without regard to whether or not there is a participation in criminal street gang activity charge is that although the Gang Act provides specific statutory authorization for the admission of gang evidence offered to prove the existence of criminal street gang and criminal gang activity, Georgia courts have consistently approved of the admission of gang-related evidence regardless of whether the Gang Act is charged or whether the victim of the offense was affiliated with any gang.
Wow.
Demonstrating the clear importance and viability of gang-related evidence, numerous appellate opinions describe gang-related evidence with no question regarding its admissibility ever mentioned. Of course, the admission of gang-related evidence pertaining to an underlying criminal offense and or defendant has been approved for a variety of purposes and in a host of contexts. Exemplary are the following areas: proving or explaining motive, connecting the defendants, explaining the defendant's presence at the scene, proving identity, clarifying the conduct of the defendants, providing context for the offenses, and or where part of the circumstances of the offense. Federal and other states' authority, Your Honor, is in accord with Georgia case law. Intrinsic evidence, which is also known as res gestae or background evidence, is evidence of wrongful conduct other than the conduct at issue introduced for the purpose of providing context in which the charged crime occurred. Intrinsic evidence is admissible without the limitations of or resort to Rule of Evidence 404B. And Your Honor, support for that is seen in United States versus Ford, 784 F 3rd 1386 at Penn Site 1393, which is an 11th Circuit 2015 case.
This is DA, man.
Intrinsic evidence, Your Honor, is admissible without the limitations of
They
or
work
resort
together
to
better than ever. Like they don't
404B
just
rules of evidence.
No.
So in federal gang and conspiracy prosecutions
They got
such
this
as
little thing going
the
on.
state
I tell you,
gang and conspiracy prosecution before Your Honor, a defendant's gang and conspiratorial activities have been classified as intrinsic evidence, including a
they
defendant's
got this
gang
little
membership.
thing going on. They
It has
trying to get
also
them out of there
included
for
prior
real.
criminal acts committed as part of or reflecting the activities of the gang or conspiracy, and it has also included gang culture evidence. So here, Judge, the overwhelming breadth and weight of this authority demonstrates that whereas here, gang activity and or association is in some way connected with a defendant or an offense, appellate decisions have consistently authorized the admission of gang-related evidence. And where connections of this sort exist, gang-related evidence is admissible over objections that it
That's
might
the thing, the
reflect
connections.
negatively upon a defendant's character. And as such, Judge, gang-related evidence should be admitted at the trial of this case. Arising, Your Honor, in voluminous contexts, a broad spectrum of gang-related evidence has been ruled admissible in Georgia, and I'll give a non-exhaustive sampling, sometimes by category. Admission in a defendant's statement, belief systems, expectations of and ongoing gang members and associates, co-conspirator statements, colors, bandanas, hugs, and handshakes, incriminating statements made during offenses, internal policies and practices, items recovered during the search of a residence, items recovered during the search of a jail cell, numbers and codes, rivalries, symbols and signs worn on a person, membership or association, photographs showing hand signals and graffiti, tattoos, and witness bias. This is exemplary of the far-ranging grounds on which gang-related evidence is admissible under Georgia law. And accordingly, the gang-related evidence that we will present to this court should be admitted at the trial of this case. Your Honor, as we've outlined in section 5 of our motion on page 15, excluding gang-related evidence would violate the absurd result rule. So a fundamental rule of Georgia statutory construction, Your Honor, is to interpret legislative pronouncements in a fashion that will avoid an absurd result. The various provisions of a statute should be viewed in harmony and in a manner which will not produce an unreasonable or absurd result. That's from Rodriguez versus the state, 284 Georgia 803 at 805, finding Georgia's Gang Act constitutional. In this case, any argument against the admission of gang-related evidence will circumvent abundant and established case authority and contradict specific statutes, namely 24-418, 16-15-9, and 16-15-3-2, that expressly authorize the admission of gang-related evidence. Such an argument would also be at odds with the enumerated purposes of the Gang Act found at 16-15-2. This is all true because the 2006, 2010, and 2016 amendments to the Gang Act, 1, specifically authorized the admission of gang-related evidence, and 2, Your Honor, lower the burden of proving the existence of a criminal street gang relative to its pre-2006 incarnations. So opposing the admission of gang-related evidence in this case is tantamount to advancing the assertion that the General Assembly's actual intent in amending the Gang Act in 2006 and again in 2010 was to impede and prevent the admission of gang-related evidence rather than create more avenues for its admission in such a result.
Do I still have to consider 403 though?
Your Honor, as it relates to 403, where we are tendering, and I can give examples of the kind of acts that we are tendering, where we are tendering in this case, for instance,
Well, subject to 403, so you agree with me about that, right?
I believe that
Intrinsic evidence is admissible subject to Rule 403.
Yes, Your Honor, I do believe that even intrinsic evidence is admissible subject to.
Okay, so assuming you lay the foundation and there's not some 403 issue that goes along with it, I think that's consistent with the current law and statutes. But what else?
So these particular other acts that we provided notice, and to be clear, there are acts again that we assert were committed by these defendants and acts that were committed by alleged opposition members of other street gangs, Your Honor.
And that's your supplemental motion filed on 11/6.
Yes, Your Honor.
And there's some almost 51 acts.
Yes, Your Honor.
Okay, and you've identified them and broken them out pursuant to individual persons, I see?
Yes, Your Honor.
Okay, all right.
I also believe, Your Honor, that, and I wanted to make certain, let me check it, that the acts that have occurred post the beginning of jury selection, post indictment and post the beginning of this jury selection, we are also intending to submit or tender evidence of those acts for the same purposes, Judge, as intrinsic evidence and as proof of count 1 in this indictment. As we've stated, each of the defendants is charged with participating in the RICO conspiracy of the Young Slime Life or YSL gang, a criminal enterprise, and therefore evidence of criminal activities committed by individual defendants will be admissible as intrinsic evidence in any of the following scenarios: where the prior uncharged misconduct arose out of the same transaction or series of transactions as the charged offenses, and that is the activities of the YSL gang and the defendant's membership in or association with the gang. So for instance, Judge, where we have as an overt act 2 named defendants on the indictment, but we also have evidence that one of the participants in a particular act was not formally indicted. We seek to admit evidence that that defendant too was a part of this particular act.
That's Gunna.
Where the prior uncharged misconduct is necessary to complete the story of the crime, and that the prior misconduct emanated from the defendant's membership in association with or participation in the YSL criminal street gang, or where their prior
You talking about
misconduct
them
is
niggas that took them
inextricably
gas
intertwined
that's
with the
out and
evidence
got locked
regarding the
back up.
charged offenses, because the prior misconduct is part and parcel to the defendant's membership in YSL and YSL's criminal activities. So, Judge, we're here. We have the Georgia Supreme Court stating in Roberts versus the state, 2022 Georgia Lexus at 15, citing
Damn, this was
U.S.
an act
versus
last
Battle,
year.
774 F 3rd 504 at 511, an 8th Circuit 2014 case.
A couple years ago.
When evidence of other crimes tends logically to prove any element of the crime charged, it is admissible as an integral part of the immediate context of the crimes charged and is not extrinsic. So evidence of a defendant's prior acts showing a connection to YSL completes the story of the charged crimes and can be
Wow.
used to show the existence of the conspiracy, which
Got
is
it.
an element
Let's
of the
continue
crimes
on
charged
that.
against each of the defendants before your honor today. So 404 limitations, 404B limitations don't apply. Where evidence is admitted as intrinsic evidence, rules about the admissibility of extrinsic evidence, such as those under 404B, do not apply. And for that proposition, Your Honor, we cite for the court's attention and consideration Harris v. State, 314 Georgia, 238 at 264, a 2022 case, where it states that Rule 404B is not applicable to intrinsic evidence. And Your Honor, none of the restrictions of 404B substantively or procedurally apply to intrinsic evidence. Therefore, when evidence meets the criteria described above, it should be admissible against the defendants. Your Honor, as we state in part 2 of page 5 of our November 30th, 2022 preliminary motion to introduce intrinsic evidence of gang activity, intrinsic evidence, as the court has now stated and recognized, is admissible subject to Rule 403, and it is admissible if it satisfies it. Although intrinsic evidence may be prejudicial, Your Honor, Rule 403 requires exclusion only when unfair prejudice substantially outweighs prejudicial value. And the exclusion of evidence under Rule 403 is an extraordinary remedy which should only be used sparingly, Your Honor. And that is cited in Chambers versus the State, 351 Georgia Act 771, a 2019 Court of Appeals case. So any evidence the state will introduce as intrinsic, speaking to the court's concern, is subject to this extraordinary remedy under Rule 403, but generally the state now moves to admit intrinsic evidence of prior criminal gang activity subject to Rule 403.
But if that's his prior, that's not like, what if he didn't know him at all? He was doing other shit by himself. Y'all just put it like we was together the whole time.
Your Honor, and to name some of the acts that we have noticed defendant of our intent to introduce evidence of, and as well, Your Honor, I'd like to make certain that I point out that acts that were not alleged to have been committed by either of the defendants on trial before Your Honor are not all included in the intrinsic acts supplement that we filed on November the 6th. So for instance, when...
Wouldn't you need to do a supplement at that point in time so I could do the same and similar analysis as what I'm doing right now?
I think that would actually help, and so I can do that, and I will do that. Some of the, and I can do that and file that.
Well, I just think it's required, but just so that, you know, everyone else knows if you have additional statements, because I don't want to necessarily slow the proceedings down,
He be telling
take
them.
up things that aren't necessarily, but we could have done prior to that. So file it, and then we can, if you have additional statements, I'd suggest that you file them, and then we can talk about them at that point in time.
Of course, Judge, and
All right.
certainly we won't mention anything.
Until
any
such
kind of
time.
open rate.
Okay.
And so if the court desires that I go into the individual intrinsic acts and explain that, I can, or I can do however the court deems proper and respond after the court has had an opportunity to hear from someone else besides me. But we have listed them out in our November 6th filing. And these are the acts that we allege involve members of YSL. Just to name a few, there is the participation in criminal street gang activity conviction of Shannon Jackson and Kenneth Copeland, which shows the prior association between Shannon Jackson and Kenneth Copeland and participation in criminal street gang activity
All them young boys.
involving the gang 30 Deep. We have noticed defendants of our intent to introduce an intimidation of witnesses in a criminal trial act. The state alleges was committed by the defendant Williams during the trial of Quintavious Greer, wherein he had been charged with and was on trial for murder.
Your Honor, I sense that Ms. Love is going to read down the list.
I don't need the list to be read, so.
My observation, Your Honor, I've been through this list with some of my colleagues, is that each of these individual quote-unquote alleged intrinsic acts or 418 acts, as the state alleges, each of them are subject to 403, and each of them individually have different levels of relevance and probative value and different levels of dangers of prejudice and the like. There are some on the list that, I don't want to speak for everyone, but I've had some people, there's some on the list that I don't think that the defense necessarily objects to.
Right.
There are other acts on the list that we object to vehemently.
They are not relentless.
And the danger of prejudice is much greater. So I think, as opposed to Ms. Love just going down the list with the defense just remaining silent, perhaps we need to be heard on each individual act and discuss the 403 balancing act of each. I just don't want to remain silent and for it to be perceived as if
Well, I hadn't given you an opportunity to argue at this one time.
Of course.
Mr.
I ain't got no
Sean, so I
argument
was
to do
going
nothing.
to do that. But
It's
the
not
other
an argument at all.
suggestion is, I was going to say that depending upon when that particular issue is going, because it's subject to foundation. So, I mean, I think it might necessarily be better for me to, before the particular evidence is going to come out, that I make a ruling on it.
Okay.
I mean, because I don't have time at this point in time to go through each 41 act to do this, and it might just be better depending upon the trial and pace of the case.
Well,
for
you
me to
gotta
go
go
ahead
through
and
that,
just
Judge.
take it up before it's before we
Well,
and make that
go through that.
ruling
It's only
And Judge,
when
right.
we get close.
what we can do to at least allay some of the concerns that counsel for defendants may have is to specifically identify any act that is on this list or that we allege is intrinsic and not charged prior to. Will we give them witnesses, let them know, hey, this is going to include this act? For instance, I think that the first list of the first 3 weeks that we had intended to call does involve, for instance, act number 4.
Okay.
And
Any other act?
it includes as well act number 5.
All of them acts.
Let me see how far down we got. Would the court permit me just a second?
Yes, ma'am.
How far did we get? On this. I said, we're talking about it. On here. Yes, this one right here. That's not what's going on. This is where I started. That was the one we talked about. That happened. And it didn't become permanent until later on, so that's further down. I'll put this on. This because it's after. For weeks, when we're doing this, all we're talking about. It does, but also at where contagious students were stopped. And here, contagious students were stopped. I don't think that's because that's him. So we also included in this, but not this. Number 14 as well, that date is 10/27/2014, but I have it mistyped as 2015.
This judge is biased in the motherfucker. Like,
And then, Your Honor, the acts that were committed by other people, for instance, the acts listed on our notice in number 13, which involved
the co-defendants.
an aggravated assault and terrorist act upon the addresses listed on Maury Avenue. Those are the homes, that is the home or relative of a person that we allege is affiliated with YSL. So there is more than one of those type of acts. Essentially what we are seeking to show is the action and then its subsequent reaction by either the defendants on trial here or an opposition party. So the opposition party's acts, of course, aren't charged in the indictment because neither of the defendants here committed them, but we will be seeking to show evidence of those. And I believe that if it was not Mr. Steele, my apologies to him for my misstating, so it may have been Mr. Sharp, forgive me if it wasn't him, but we spoke about whether or not there would be objections to information or evidence presented regarding what other people did for instance, opposition shootings. And I think that someone had said that there may be objections to that evidence as well, so.
Other than 4, 5, 13, and 14, are those the instances that you seek to admit the first 3 weeks?
One second, we're just going over it to make sure. Um, 15, Your Honor.
Anything else? Because I'd like to take up those at this point in time right now so that you'll know whether or not they are admissible or, or subject to any other issues.
Okay.
And give the parties, whoever it is.
Wow, this shit, they shouldn't be allowed to have. Well, make sure y'all hit the like button. Make sure y'all share this, man. Share this video, man. Get this out there. We gotta get this judge off the bench.
Looking at the list, Your Honor, yes, I think that is.
Okay, all right. We won't take up those just a second. Do I have any other issues that I say at this point in time other than this 418?
We have a motion from Mr. Steele that the court may have already addressed that related to, and forgive me if the court has, a motion, it's filed on November 17th, and it's a motion to redact from the indictment any and all
Covered that
language.
this morning.
We did, okay.
Yes.
And
You owe me an order on that.
so, okay, the one regarding the vehicle closely following Mr. Williams containing 4 individuals armed with numerous weapons and high-capacity magazines, to include AK-47 with 30-round magazines from the May 18th, 2018 traffic stop as contained in count 1 over Act 75. Did we hear that one?
That's the one that you all, is that Williams 37 or 36?
No, actually, this does not have a number to it. It was
Cause I
just
just threw that
filed.
in there.
As I just read to the court, it has a longer title and it's filed November 17th. I have a copy I can present to the court.
Y'all just throwing charges on that nigga.
Is this pursuant to, let me see. I think this may be part of what we covered this morning. No, we haven't addressed it specifically, but is there any other argument as to this, Mr. Steele, you want to make? And also, I'm going to ask, so let me just kind of deal with that.
Sure. This is.
Your Honor, this deals with count 1 over Act 75, and I did ask the Honorable Court to redact some of that language. You previously heard a motion to suppress. You denied my motion to suppress. If this jogs the court's memory, there were 2 vehicles. Mr.
Yes. Yes, sir.
So my position is the fact, and we heard the evidence, and you said, I'm going to deny your motion to suppress. However, there has to be some link to be tied up, some foundation that Mr. Williams knew that there was supposedly weapons in the other car. And, when I go through this, I don't see any evidence of that except the police officer's theory at the scene where they drive in tandem. And
I
so
remember
that's
that.
it.
I remember that. Okay.
And I raised it at the time, and that's why I moved to suppress, and you said you weren't going to suppress it, but you understood the issue and we would take it up later.
Yeah, okay. So is that, Ms. Love?
That is the motion that I'm speaking of. And of course, Your Honor, that from our perspective, that evidence goes to weight, not admissibility.
It would.
I'm sorry.
It would
Okay.
go to weight and not admissibility necessary, meaning that you can present evidence on it. Of course, if you're able to substantiate that, that's fine. But, Mr. Steele's just, I guess, asserting that the only evidence you have is the testimony of that
That cop.
officer, but that's an issue for the jury to decide. So, Mr. Steele, I'm going to deny the motion to reject at this point in time.
Wow.
So you can include that, Ms. Love, in the order for the motion to redact the indictment. You can just put that we've considered this particular motion as well, and that if you can either do a separate order, you can add that to that issue.
Yes, Your Honor.
Okay, on the 27th. All right. Okay, is there anything else I'm missing at this point in terms of any other additional motions, madam? Okay.
So, Your Honor, we also have, and this may have been included, I'll let the court instruct us, the motion to redact the indictment from showing any and all co-indictees who entered a guilty/Alford plea as distinguished from the entered a guilty been included. I'll let the court instruct us. The motion to redact the indictment from showing any and all co-indictees who entered a guilty/Alford plea as distinguished from the motion to redact the indictment. So this particular motion was filed by Defendant Williams on November 3rd, 2023, wherein Mr. Williams moves the court to redact from the indictment any evidence that a co-indictee entered a guilty plea
Right.
if the bill of indictment is to go out with the jury during deliberations. And that's all that is asked. So I guess that this is something that could also be taken up at a later time. We are in opposition to the granting of this motion because our position, Your Honor, is that any admission of guilt by a co-indictee or co-conspirator would go to an element of proof as to at least count one, perhaps others in this indictment. And the fact that a guilty plea may be an Alford plea or something otherwise makes it no less a guilty plea or an admission. So we would ask that to the extent that this is different than the one we addressed this morning, that the court deny this motion as well.
Mr. Steele, let's say.
So, Your Honor, just for ease, Sergio Kitchens, I'm just picking out his name. He pleads Alford before this honorable court and receives a sentence.
Right.
And if the state does not call him, or if the defense does not call him, my target is the fact that he pled Alford on the indictment that may go out with the jury is offensive to Mr. Williams and the other people because it bolsters wrongly the state's case. And it is not some admission that can be used against Mr. Williams because, and Your Honor,
You talking about like the indictment itself it's got signature pages on it?
exactly.
Oh,
It's-
we don't have
I don't
any
submit
objection to that.
it's not usually my pattern and practice, Mr. Steele, to submit those anyways. Once you all get a dummy, my pattern and practice is to use a dummy indictment that both sides agree upon that goes to the jury. So they won't have any signatures on it.
Perfect. I mean, they'll have, I assume the people on trial is not guilty pleas.
Yeah, they'll have a stamp on it and everything else, but it won't have any signatures necessarily that from other folks.
Okay, that's great.
Your Honor,
And
I'm sorry.
No, please.
I just wanted to point out that I don't disagree with the signature page not going out, but to the extent that a guilty plea, a certified copy of a conviction
That's different.
is tendered, right?
If that's tendered in the case in chief, then that certainly is separate. But in terms of just to that extent, whatever we come up with that is shown to the jury in terms of the indictment, who's ever left at that point, we can discuss that issue at that point. So, but no, I don't usually include a signature page.
Your Honor, if time permits and energy permits for everybody, would you take a peek? I don't have a physical copy, but and everybody, if you don't mind, it's State versus Jefferson, if this is a proper time on that issue. And it's 302 Georgia 435. That's 302 Georgia 435. It's a 2017 case.
302 Georgia what?
302 Georgia 435. It's a gang case, criminal street gang case. It's written by former presiding justice or chief that then became Chief Justice Melton.
And
So what happens is there's 4 people who go to trial or on trial together that charged with a conspiracy, including but not limited to murder or attempted murder, maybe kidnapping, violation of violation of Georgia Street Gang Terrorism Prevention Act. So that's why there's other cases on this, but that's why I target it. And Your Honor, in the paragraph that's on page, let's see. It's an indented paragraph, I believe, Your Honor.
Yeah, what are you asking me to consider, sir?
Exactly what you just said about it's different about a certified copy of a conviction.
Yes.
It says, and I'm quoting, and it's, I'm trying to get the jump site. It's in the paragraph, a beginning, contrary to the state's assertions. I don't see a page though.
I think it's at Penn site 441,
Thank you.
section 2.
Thank you very much.
This is State v. Jefferson? Is that correct?
Yes, that's exactly right.
Hold on. I got you. Okay. All right, so it talks about they can't do business records.
Well, no. Well, yes, you are correct. But then it goes further. And if you find the indented paragraph that starts with testimonial evidence.
Yeah.
Okay. Encompasses not only prior testimony of the that the defendant was unable to cross-examine, but also judgments of conviction based on trials during which the defendant was unable to cross-examine when those convictions are used as proof of facts underlying the crime charged. Because third-party convictions, and that would be the convictions we're talking about now, Mr. Kitchens, Mr. Arnold, whomever, unless they testify.
Yeah, it's sequencing.
Okay, if they
I
testify,
don't have any issue. It's sequencing.
We have no objection.
If they don't testify, we're good. If they
Okay.
testify, then of course, then things are a little different.
and I thought what Ms. Love said, and I thought the court said, was that simply if state can stand up and say, by the way, 8 people have pled guilty in this case, and now I'm
It's an
saying,
issue of sequencing, and also it depends upon whether or not, who is the state's burden to prove, but those kind of things would be dependent upon who testifies. If so, and they don't have to, so.
and if they testify, yes, obviously I have a confrontation right there.
Yes.
Okay, yes.
Okay.
That was it.
All right.
Thank you.
Yes, sir. So can the state prepare a suitable order for my signature on that particular issue as well?
Yes.
That was the, what's the title of the?
It is titled Motion to Redact the Indictment from Showing Any and All Co-Indictees Who Entered a Guilty/Alford Plea, filed November 3rd.
All right, so there's basically a couple of motions to redact the indictment.
Yes.
Okay, all right, so you can include that in there, madam. Okay. All right. Anything else that has not been addressed as of yet? Other than the 418, which we're gonna. All right, while you're looking, Mr. Weinstein, any motions I have not dealt with pertaining to your client?
No, Your Honor.
Mr. Matthews, anything in regards to your client, sir?
One second.
All right. Same crew to you, Mr. Harvey. Anything else I have not resolved in regards to your client?
I think there was a motion to eliminate recently filed based upon some recently provided
This one's
screenshots.
crazy.
There's a motion to eliminate with regard to screenshots.
That's all I can
I
say.
think I covered those already.
Hit the like button, man. Hit the like button, y'all.
I don't.
This judge is
So,
real biased.
My recollection, I could be wrong, because they were fairly recently provided, so,
What, do you have that motion, sir?
no,
Do you have a copy of it?
no.
But you let the
Okay, I'll find it.
you let the DA put shit in the other day, 4 days ago.
Could you, Christina? But just, yeah, I want to take a break. That's fine. All right.
Your Honor, I'm about to pull it up. I can email it to the court and opposing counsel if it's easier.
That would be great. Okay. All right. Mr. Shard, anything I haven't ruled upon?
No, Your Honor.
Mr. Steele, anything else?
We do have outstanding motion, but you deferred.
Other than the ones I've deferred, sir, that specifically I've dealt with, do you have any other new ones that I've failed to address already? Because I know you're going to remind me of the there's about 2 or 3 or 4 that may come up depending upon what is presented. So you can just, before that time, just remind me that I need to do that. But do I have anything new or outstanding that I haven't ruled on, sir? Okay, all right, just want to make sure. Mr. Williams, anything now? Yes, Mr. Matthews.
There is a motion in remedy that I did file. I'm looking now, I filed it maybe a week or 2 ago. And once I pull that, I'll share it with the court. It was concerning redacting or excluding certain, in the event that the state decides that they want to introduce Mr. Huey's statement. There are certain aspects of the statement where certain information that he provided that I think are not relevant and possibly prejudicial. So I filed a motion limiting that regard. I'll pull that motion. I'll re-forward it to Mr. Kearns.
Just re-forward it to me. You can forward it to Mr. Kearns as well, but forward it to me as well as the state so I can look at it right now. If you wouldn't mind, sir. All right. Was there anybody else? Or any other things, Mr. Matthews?
No, Your Honor.
Okay, all right. Anybody I've not otherwise addressed as of yet? Okay, so Ms. Hilton, you're forwarding that?
Yes, you should have.
Okay,
it.
anything else in regards to the state?
I did have one thing, I apologize. Hold on.
Yeah.
You ordered us, I asked for it up, and you said, yes, do that.
What, I'm sorry about what?
I'm sharing I have a PowerPoint.
Yes.
Share it, so I thought you'd want to know that for everybody.
Did we deal with that issue already? Or have you all?
You said to share it well before opening.
Yes, I did.
Any issues you want to resolve before we place it.
Well, yeah, that would be a Monday morning thing but I would hope that you all share with each other before Monday morning so that I don't want to take up too much before this jury comes out because I'd like to really kind of go ahead and get started. So if you all, to that extent, are you in the process right now of sharing your openings in terms of whatever the PowerPoint is? I know you all said you were going to do that. So,
I should have it done sooner than today, okay?
all right.
But tomorrow, I'll lay it back, I believe I'm going to send it over to everybody.
Okay.
And we will do the same once we.
Just to be clear, we come up with demonstratives.
Anything that you're going to use in opening. So there's no surprises. And speaking of that, if you all, I can either, in terms of, for those of you that wish to make opening statements, I'll give you the opportunity to do so. It's built into what I tell the jurors. So you can be prepared at that point in time to make your openings in whatever order you want to, or I can pick one. We just do numbers out of a hat.
Your Honor, can we do that for cross-examination as well? Like if Mr. Sharp really about his time, but I want to cross-examine you. Can he go first if he wants to, and then I'll go second? The next witness.
Sure, I don't have any issue with that. I'll pick unless there's, disagreement to the contrary or non-concurrence. So I'll do that in the absence of agreement. Okay.
Your Honor, as it relates to opening, I don't.
Answer my first question. You have any other motions?
I moved the court for all day to do up to the kidding. No, I'm
Okay, all right, because I'm trying to get things done so you all can have a relatively, as much as we can, smooth Monday for our juries. Okay, so I'm trying to rule on everything that's outstanding so I don't owe anything to anybody, or if somebody doesn't say, well, Judge, you didn't rule upon this, and I want to make sure because it's in my opening statement. I don't want to have that. So I'm trying to make sure that we've covered everything that potentially might be an issue that I otherwise have not deferred ruling on yet for reasons thereof. Okay. What's your question as to opening, Ms. Love?
Your Honor, is the court, are the parties constrained time-wise with openings?
What y'all
Could the
got
court give
going
us
on?
just any direction that you have in mind at this moment, not trying to tie?
Brevity is good, Ms. Young. Ms. Love. Brevity would be good.
I don't know what that means.
I've done this a lot. Look, I will afford you a reasonable amount of time, but I'm not gonna cap you. I just hope you're not gonna go 3 hours or 2 hours.
I'm not going to cap
But
you.
that you I remind everybody about the concept of primacy and recency.
I'm not.
So, but
Okay.
to that extent, you all need to make whatever opening statements you need. Yeah, you think they're within your entity's best interest.
Oh, and Your Honor, we did have one more matter that a colleague wrote.
What was the other matter, madam?
Was, Your Honor, we can address it whenever the court deems fit, but the court indicated after ruling with respect to one of our motions as it related to statements that were made and captured on a body-worn camera, that the court might be inclined to consider a motion for reconsideration. We did file one.
No motion for reconsideration of the body camera. I didn't say that.
Okay.
No.
That was wishful thinking. And yeah.
Okay. Done. Don't bring that up again.
Understood.
All right. Okay.
Got it.
All right.
No problem.
What else? Do I have any other administrative inquiry about Monday? I'm going to go through, after I welcome our jurors, I'm going to go through the standard covering them, what they can expect.
And
I'm going to
they
probably
really
reiterate
trippy red.
the issues involving the ad nauseam admonitions. And then let you all get started.
What time will we begin on?
9 o'clock.
Your Honor,
Sir.
do you know what time we can enter the court room or courthouse?
I don't know if Mr. Coons got to that letter or not, but we'll just deal with it the best way we can. I'm going to try and get, I don't know if I signed it, and I don't know, because he was working on it before he left. to get, so I may have to complete that Monday, Mr. Steele. So just remind me, but I was gonna do an order to get all of you. Did you all provide that to Mr. Kearns? I think he was working on it.
Excuse me, Judge, I believe that order went out a day or two ago.
All right, so I think it's at the desk already. So you should be able to get in early, Mr. Steele, before 8 o'clock or thereabouts. Okay? All right. Okay.
Yes.
I'll do with this motion to exclude the screenshots and the motion limiting as it pertains to Mr. Harvey's raised and Mr. Matthews, but let me go ahead and take up the 418 issue. So let's start out with number 4. It's 5/12/2013 matter.
This DA is for the way.
Your Honor, the act listed as number 4 in the intrinsic acts filed by the state involves a home invasion that was committed by, we allege was committed by Mr. Williams and Mr. Murphy. The victim in that case, I don't want to broadcast the name, but we have provided the defendants notice of and discovery for that particular incident. There was a police report that was filed, and just for reference sake, it is APD case number 131331506, where that named victim reported to the police that defendant Jeffrey Williams and co-conspirator Walter Murphy, along with another party, committed a home invasion, and that they burst through her door, held her at gunpoint, and stole items belonging to her, including but not limited to a firearm, as well as money. The defendants are alleged to have then left the residence and fired a shot into, I believe, the door frame of her residence before leaving. The victim in that case went to the police station and reported the home invasion after being urged to do so by her mother. The police spoke with a juvenile witness on scene who was a neighbor. And later, the police reported that the defendants returned the property and apologized for committing the home invasion. Your Honor, the state's position is that the act of the home invasion with the co-conspirator Walter Murphy, committed by Jeffrey Williams, is an overt act that tends to show and to prove defendant Williams' understanding and willingness to participate in racketeering activity and to conduct YSL through a pattern of racketeering activity. It is an overt act that the state will tender evidence of. We will not and do not intend to make any mention of that act unless and until the state has presented evidence and the court has admitted that evidence.
All right.
It shows, again, the types of crimes that the group commits. It shows the earlier relationship between the defendant and an alleged co-conspirator, Walter Murphy, who now has entered a guilty plea. And the victim in that case is tied to a gang that is an opposition gang. If the court wishes that we just address them one and then
I'll
let.
just do that, yeah. I would like to. Thank you, Ms. Love. All right, Mr. Steele?
Thank you, Your Honor. This is allegedly May 12, 2013. It's Mother's Day. The alleged victim, just for purposes of this motion, is A, as in Elisa, or Alpha, B, as in Barry or Bravo.
One is sufficient, so I prefer you use Alpha or Bravo, okay? The list is on the podium too,
All right.
so if you cramp up, you can just use that, okay?
I'm trying to
No,
learn.
you'll try, you'll get there.
This is the facts in the report are a little different than the way I understand it, than what the state said. So what I understand is it's not a home invasion. It's Miss A.B. Reports to the police that Mr. Williams is friendly with her boyfriend. They were allegedly together the night before. She said because of that, she didn't think anything of it, opened the door. She states that Mr. Williams and Mr. Murphy and Mr. Williams' brother, she does not say who it is, comes into the home. And supposedly, when she turned around, there was a cell phone and some money taken. And Mr. Murphy supposedly fired into the wall in the house. She did not report anything to the police. The next day, she made this report that I just told you. The night, so that happened during the day allegedly. Then that night, supposedly bullets were then entered into her home. Nobody says it was Mr. Williams or Mr. Murphy or anybody else. There's no evidence of who shot later into the house. She did make that report. The police never made an arrest. The police report finds that AB was untruthful. Mr. Williams was never arrested nor charged. The state first noticed me of this.
Is AB gonna testify?
We can list her.
Okay. So I have tried to find AB for months. I found AB when the state first gave me her information, and she supposedly lives there, but I can't get her. And that was on September 26, 2023. That's one of the people I need to interview. I never interviewed.
Is she gonna be, I was gonna just ask you that. Is that somebody that you're gonna seek to interview and also run a criminal history in?
Absolutely.
Okay, all right. Let's assume that she's available. Would that change your, I'm sure you probably disagree still, but would that change the analysis or argument?
Well, I have factual analysis and I have legal analysis. The state's notice, and they did file in, I believe it was October 2022, a preliminary motion to admit.
They did.
Gang evidence, but it's like a boilerplate. There's no specifics. The specifics come on November 6, 2023. And I'm including, this is just how I look at life, I'm including September 26, 2023, because on that witness list we got, that was the good witness list when you made it known that this is unacceptable. And on that witness list, it does say 418. So I took that as notice. So September, this past September. But notice according to statute has to be 10 days before trial. We've been through that a lot, but that's in the statute itself. And this is not 10 days before trial. And, Your Honor, because Mr. Williams was never arrested nor charged with this. There is a great presumption not to admit it because, let me get to the case. Because the prejudice is great and the danger to admit this type of act where the accused was not previously charged or convicted is too great, and that's Rivera, R-I-V-E-R-A versus State. Your Honor, it just came out, so I have a site, the case site. It's S as in.
You have a Westlaw site or?
I have the,
Hold on a second, I'm just gonna pull it.
it's,
Alexis, Alexis.
if you have it, it's S23A 0429, if you can.
You want Alexis right there?
Yeah, the county only allows me to have Westlaw, so.
That's more expensive.
I can,
What's the
S23A
S23A?
0429. It's Division 3.
Let me see if I can get Rivera. Look at that.
These motherfuckers are just crazy, y'all. Let's see this shit.
Yeah, I do have a Westlaw. I was able to get a Westlaw site, Mr. Herman. So yeah, thank you. All right, see what we got right here. All right, so.
So that's one reason. So I have that the facts, are not, I'm not saying Mr. Love did that intentionally. The facts I'm just taking from a report because that's all I have. The facts are not the home invasion, the shooting that night, 1, 2. The notice is just late. I mean, that's just fatal to me. There was no reason for it. 3, Rivera does say the language, and it's 403 analysis. It's in the paragraph, the last paragraph before Division 3. We recognize that the admission of this other act evidence carried a risk of prejudice to Rivera, particularly since the state did not demonstrate that he was charged with any crimes arising from the Irwin County instance, and because the state chose to emphasize the Irwin County instance again during closing argument. And there's many cases on that, and it's in here. It says under Hood versus State, noting the danger of admitting extrinsic offense evidence is greater where the extrinsic activity was not the subject of a prior conviction, because the jury may feel that the defendant should be punished for that activity, even if he's not guilty of the offense charged. So, that's my other reason. My fourth reason is the state said that they need this evidence for specific reasons. And I challenge those reasons because I'm not challenging anything. They said there was a relationship with Mr. Walter Murphy. Your Honor, I will never say that there's not. These two gentlemen grew up together. Mr. Walter Murphy has been on tour with Mr. Williams. There are photographs of them that the state served in discovery together. So the fact that they want to prove a relationship is not needed. When Ms. Love said, Your Honor, it's also important to admit this because Ms. A.B. is part of an opposition gang. She said that was her last reason. Yeah. Your Honor, look at the date. This is 2013. That opposition gang doesn't start until January 6th of 2015. That's
Isn't
when.
that a weight issue? I mean, if it's admissible, doesn't the jury have to decide that?
No.
Decide that issue?
Never, because if it's opposition gang, but they're not opposed at that time, that Mr. Williams was friends.
But it shows that, okay.
She let him in the house. That's what I'm pointing. This does not go to the RICO count, and to show that there was some hostility. And this is not 418 evidence. If you heard what Ms. Love said, this is not 418. This goes to, she's trying to say this is for the RICO count. RICO is not 418.
Well, Rivera talks about 413, and actually 413. But do you have anything that respect about the 418? Or is there, am I missing something in Rivera?
Well, I could give you other cases if you want. You mean for the proposition that a person's not arrested and it could be unduly
What
prejudicial?
division is that in?
Division 3 in Rivera.
Division 3?
In Rivera, yeah. It's the last full paragraph.
I got it. I see it. Okay. All right.
And the court found that, yeah, it might have been error, but there's substantial evidence against the person, so let's not do it. And that's the final thing that's going to be throughout all this, Your Honor.
Okay.
I know you're going to be fielding a lot of objections on admission of information and evidence, but the bottom line is this. I probably can't get around. There's 191 overt acts already in count 1. How much more does the state need? And that's under Thomas, Thomas. I'll give you that site. It's the prosecutorial need under 403. There's nothing. There's no prosecutorial need here. What Ms. Love said, the 3 reasons that she wants to admit it is understanding and willingness to participate in RICO activity.
Types of crimes and in relationship with co-conspirator.
Right, relationship with Mr. Murphy, the opposition gang, which at that time it is not. There's no opposition gang. Actually, I'm proffering to court. I promise you, this is accurate. Those 2 alleged gangs were friends. You heard that from some of the experts who testified. So that's not a reason to admit this.
Right.
That'd be like saying, you know, Bruce Harvey and I got into a fight today, and then 5 years from now, Bruce Harvey doesn't like me. We're friends today. I mean, it doesn't show anything. And then it's really propensity. And we're not in 418 where propensity is okay. We're in RICO. This cannot come in under 418. And
I'll tell you what. I think you all need to probably talk to the witness. Because you all proffered a lot. And you haven't, has the state interviewed the witness at all? Yes, no? Have you interviewed AB?
Oh, Your Honor, we have.
Come on, answer my question.
We have endeavored.
That's a no. Okay. All right. I think you need to interview her before I conclude on this, because that may resolve part of your issue.
Okay.
And then I'll just defer ruling on it.
all right, I understand.
I mean, let's just make sure that that you've been able to kind of substantiate what you think she's going to tell you before I rule upon it.
Okay, and then, and then just for I'll back down, but just for all these that we're about to go through, I'm gonna have a final argument, everyone. If there's 191 overt acts, I mean, how much more? And you let in, respectfully, over my objection, you let in 19 lyrics. I mean, at some point, we gotta go. I mean, this is just extending it. Anyway.
I understand.
I know.
Okay.
Thank you.
All right, let's cover number 5, and that's the incident on September 11, 2013.
Yes, Judge. And with the court's indulgence, I briefly just wanted to touch on the fact that the state is not intending to proffer to this court that we are offering, as if it were a 404B proffer, these acts for specific exhaustive purposes. Your Honor, the act itself that we are tendering, specifically the one just addressed by Mr. Steele, also would go to prove the existence of an enterprise, the existence of an understanding and willingness to participate in and conduct this enterprise through a pattern of racketeering activity. In no way did I intend that the court accept the recitation of events that I presented and reasons that I presented as an exhaustive reason for admission or exclusion.
Right.
So I wanted to make certain that that was.
But you're introducing it for intrinsic purposes, and
right.
So why are we okay?
And so,
I'll defer ruling on it until you need to interview the witness first and then determine what you know. Because you don't know. I mean, unless you talk to this person, which you haven't yet, you can't proffer any of this stuff to me at this point. I mean, you can, but you all made argument, but I can't rule on it.
okay.
So let's circle back with that at a point in time. I'll just defer on it at this point in time. So let's move on to the September 11, 2013 attempted armed robbery, fleeing, attempting to elude at 13 SC 122087, Walter Murphy, Mr. Williams, and Adrian Bean.
Yes, Your Honor, just one moment, if the court will allow me. Your Honor, this particular event or act is one of the overt acts that is listed on the indictment itself. Specifically, it is listed in the indictment as act number 4 through 7.
Yeah.
But in the indictment, Your Honor, only Mr. Murphy is listed. What we have, Your Honor, is evidence of, and this was provided to the defense in July of 2022 in the report that we referenced in the prior act that we seek to notice or introduce evidence of was presented in 2022 as well. So this particular act involves a co-conspirator who is alleged to have committed this particular crime with the defendant, Jeffrey Williams. Specifically, in this case, Derek Dotson is someone who was targeted by members of YSL for an armed robbery. Mr. Dotson had a substantial amount of money on his person. Mr. Dotson is also deceased, so he won't be testifying, but there is a plethora of information about the incident that is available and legally admissible that the state will be presenting. Mr. Dotson was robbed at gunpoint. I'll just state in my place that the information we provided to the defendant shows that Mr. Dotson, when speaking with police, was yelling, "Thug is the only one out of that group that knew me. Thug had this happen to me. Thug made this happen." So as we listened to the jail calls of the people who were caught, Mr. Dotson's robbed at gunpoint. Mr. Murphy holds him at gunpoint. While Mr. Murphy is attempting to rob Mr. Dotson, he is in the car previously to this, prior to the robbery, he's in the car with an Adrian Bean and the defendant Williams. And when Mr. Murphy gets out of the car to rob Mr. Dotson, a law enforcement officer, Roberson L., is nearby and hears the commotion, responds. When the law enforcement officer responds, Mr. Murphy begins firing shots at the law enforcement officer. As that happens, Mr. Bean jumps out of the car, goes right. Mr. Williams jumps out of the car and goes left. And during a subsequent jail call between one of the witnesses and his wife, the witness says, "I should have followed my mind. Thug went left. I should have followed him, and instead I went right." Police then go and take that witness out of jail and interview that witness, who will be here in person to talk about it. And he then tells the police how Jeffrey Williams orchestrated that particular armed robbery.
Have you interviewed the witness yet?
Yeah, we have talked to that witness.
Okay, all right.
So, Your Honor, that is significant because later on, during the Jimmy Winfrey shooting, which happens in 2015, in the latter part of 2015, Walter Murphy is one of the members of YSL who is on scene at the compound at the Lil Wayne concert before the bus shooting occurs. While they're at the compound, the court has heard some testimony from Investigator Dennis about what took place. But after that, Your Honor, Mr. Murphy and others were interviewed. And one of the things that Mr. Murphy said that is telling is that he had done enough for Thug. All that he is required to do now is watch his sisters. So, Your Honor,
Wow.
this particular act, this armed robbery, again, shows Mr. Williams' tacit, if not explicitly stated ever, agreement to participate in and conduct YSL through a pattern of racketeering activity. It shows the actions of the participants in YSL, the criminal actions, the type of crimes that they're committed, and in no way am I intending to offer an exhaustive list of why it's admissible. It's admissible because it's intrinsic, it's the state's position. And contrary to any representations otherwise, it's not that, you know, this evidence is prejudicial, as I think was referred to by Mr. Steele in Rivera. The prejudice that exists in relation to particular evidence when there has been no arrest. But the risk of prejudice has to rise to the point of being unfair prejudice, which substantially outweighs the probative value of the evidence offered. And there's not an analysis under 403 relating to the need for it as there is under 404B. This is, again, intrinsic evidence of the existence of and conduct of the enterprise YSL itself in the earlier stages. So we would ask that the court not exclude this relevant, pertinent evidence from the jury's consideration. And I will reserve any further comment or argument until such time as the court permits me to
They
respond to
trying
Mr.
to pin
Steele.
Thug with this shit.
Okay, Mr. Steele?
You know, it's now an infamous day in America or the world. It's 9/11/2013. Mr. Dotson is supposedly, it's not an armed robbery, it's an attempted armed robbery. There are 3 people there. There's a car that is borrowed from another person. It's being driven by a gentleman named Mr. Bean, B-E-A-N. There's a Mr. Plethro, P-L-E-T-H-R-O, supposedly in the car, and Mr. Murphy, who's a co-indictee. There's zero evidence that Mr. Bean and or Mr. Plethro are involved in any criminal street gang activity, including YSL. Mr. Dotson is unfortunately, from other unrelated reasons, no longer with us. The state has never given me any type of notice as required by law to introduce any type of statement from Mr. Dotson. The statement was not anything of Thug did this, Thug did this. What he said was, which I don't know how lawfully anyone can get it in to evidence under a rubric of a statute, but what the gentleman said to law enforcement, so his confrontation clause matters, is I saw Thug earlier today. He knew I had money. That's what he said. He never sees Jeffrey Williams. He doesn't put Jeffrey Williams there. Mr. Plethro is interviewed. He is shot. So when the shots go off, law enforcement is already in the area. They're there immediately. Mr. Bean is driving this vehicle. He almost strikes the police car and the police officers. There's a chase. Police officers are firing at the car. The car goes off a careen like an embankment. It goes over a police car and slams into a
Man.
side of a laundromat. And Mr. Bean is captured. He's running. Mr. Murphy's shot, taken to the hospital. And Mr. Plethro's shot, taken to the hospital. Mr. Plethro is recorded in the hospital. He names people who are there. He names Mr. Bean and Mr. Murphy. He does not name Mr. Williams. Mr. Murphy is interviewed at the hospital. He doesn't name anybody, but he says that there are, he does not name anyone at that time. Years later, Mr. Bean, excuse me, if I said Mr. Bean, I'm talking about Mr. Murphy. Mr. Murphy is giving a proffer in this courthouse. Actually, the Honorable Suri Chada Jimenez is the prosecutor in that video. And Mr. Murphy's represented by the Honorable Jacoby Hudson. And in that proffer, the state is constantly asked about Mr. Williams, and this proffer is in the summer of 2015, years later.
Man.
Mr. Murphy never says that Mr. Williams is involved in this armed robbery. He never said, what he says was, I've done all this work for Thug. He carried bags for Jeffrey Williams while on tour. These two people grew up together. He said nothing about a
Is
crime.
Mr. Murphy testifying at trial?
Yes. Well, I've interviewed him about this, and he stays with his prior statements. So maybe the state has different interviews with him, but that's what he told me. He's not involved. Mr. Williams is not involved. In addition to that, Your Honor, Mr. Williams is never charged. He's never arrested.
Questionable.
It is an overt act. It's in 4 through 7. I don't know if you still have the indictment, but if you look at it,
I do.
if you look at it, Mr. Williams is not named in overt act 4, 5, 6, or 7. I don't have my indictment in front of me, so I don't have the page number.
I can find it. Okay, I believe that Mr. Williams is actually named in 4, overt act 4.
He should, if you look at it, I'm not looking at the indictment, but this is September 11th, 2013. He should not be in any of the.
I'm sorry, this is the, says on or about, if I'm looking at the right one, part 3 action, furtherance of the conspiracy, I flipped too far, let's see. Is 9/9/2013.
That's the different, that's what you admitted the other day.
Okay, that's different. Okay, all right.
Yeah.
So let me see if there's any. Oh, okay. It's Act 5. It is. You're correct, Mr. Steele. 9/11/2013. Okay, we have over Act 5 is Walter Murphy. 6 is Walter Murphy. 7 is Walter Murphy. Yes.
So I'm not charged with it. They're not, I got no notice of a Mr. Dotson, which is D-O-T-S-O-N, by the way, any type of statement. So I don't know how that comes in. And it was to the police. So it was confrontation clause. And it's prejudicial. And
Okay, Mr. Johnson is deceased.
yes, he is. He's no longer with us. That was an unrelated, this is a decade ago. So
I'm sorry, what was the last thing you said? I apologize.
this is a decade ago. It's September 11, 2013. He passed years later. So, the state doesn't need it. And I hear their reasons, but their reasons are not being litigated. I'm not opposing that Mr. Williams knows Mr. Murphy, and Mr. Williams is involved in overt acts, numerous overt acts in this case. I mean, why am I litigating something
these
that was
acts.
never litigated then? And then you have to go back to the Rivera case, which teaches us that the jury could, I'm not saying they will, but they could look at it and say, well, he wasn't punished for that, and I believe it, so it's, even though he's not charged here, I'm going to convict him. And that's exactly what is going on here. And it's for propensity. And we're in a RICO. We're not in a gang. I understand certain, like, crimes against children, God forbid, or sexual crimes can come in for any purpose, and gang act evidence. But this is not gang act. This is count one.
But this is a prior conviction. Rivera seems to indicate that it says, noting the danger, it references Hood, 299 Georgia 95 105. The danger of admitting extrinsic evidence is greater where the intrinsic evidence was not the subject of a prior conviction, because the jury may feel the defendant should be punished for that activity, even though he's not guilty of the offense charged.
Right. And that's what I have. Mr. Williams was never arrested, indicted.
They're trying to use the 13 SC 12207 incident.
No.
That's what's referenced in their 5.
Yeah, but Mr. Williams is not charged. It's what you just read is on point to Mr. Williams. That's the whole point of bringing in other act evidence that was never charged. It can really get jurors to say, you know, I'm going to get him for this one. That's a 403 analysis. And 403 talks about prosecutorial need, and they don't need any. They have 191 overt acts. And I understand, Your Honor, you know, I'm made it known throughout. I'm challenging the admission and the applicability to Mr. Williams of all the 191 acts, but the state has always pushed back and said, no, we're going forward with every 191 overt acts, because we want to show that the act of one is the act of all. And if that's true, why would the state need anything further? It's already enough. I mean, I have 109.
Okay, well, here's the thing. Would it make a difference if Walter Murphy testifies that, you know, yeah, Thug and I ran together and the state asked them applicable questions about membership or whatever? Wouldn't it depend upon whether or not Mr. Murphy testifies to?
No, because
as to whether or not this overt act is. I mean, here's the thing. Even though Mr. Williams wasn't charged, is Mr. Murphy going to identify Mr. Williams in this particular 9/11/2013 act?
No. And I haven't heard the state say the opposite.
Madam, yes.
Your Honor, so there are a couple of things. We expect, or we believe, that Mr. Steele's argument that he's making to the court right now goes to the weight of this evidence and not its admissibility, particularly because he keeps pointing back to Rivera, which deals with extrinsic evidence of an act having nothing to do with the act the defendant is charged with at the time of that trial. Here, Your Honor,
It's intrinsic.
it's intrinsic, and not only is it intrinsic, but it's one of the ones that Mr. Williams has had notice of and discovery on since day one, the entirety of that file. So that, not only what I have just said, Your Honor, but Mr. Williams' part in that attempted armed robbery and that aggravated assault, it completes the story. And it also proves other aspects of crimes alleged in this case that the state has the burden, the state alone has the burden of proving.
If Mr. Murphy is going to testify about what Mr. Williams did, I'm going to allow it.
And Your Honor, not just Mr. Murphy, but there was Mr. Bean.
Yeah, if there's going to be testimony about acts committed allegedly, and I'm sure that you'll examine them as to it, then that overt act, I'll allow the state to probably present that, even with the court doing a 403 analysis. That would be relevant to show participation, among other things. But assuming that, and that's assuming, Mr. Steele, that there is going to be direct testimony from people Mr. Bean or Mr. Murphy about the alleged incident on 9/11/2013. I'll admit it over a year. Subject to a foundation and other objections, I'll at least allow the state to attempt to present that.
Your Honor,
Wow.
it's one of the overt acts that we'd be offering evidence of anyway.
Yeah.
And we would never, if we don't have a proper foundation, or if we don't have competent evidence by which to admit
You won't
a particular
present it.
allegation or act against a defendant, we're not going to proffer it in front of the jury and then.
Well, I would hope
like,
not.
in our faces, that would be.
I would hope not,
contrary to
but
everything.
Mr. Seal's got a job to do, and you do as well, and I don't have any issue with that. So, Mr. Seal, I'll over your objection at this point in time, subject to a foundation and further objections. Okay.
Yes, sir. Can I have it for purposes of
Foundation and further objections. Okay. Over your objection at this point in time, subject to a foundation and further objections. Okay.
Yes, sir. Can I have it for purposes of this ruling? Can I have a continuing objection? And
You
I'll-
may, but I would suggest that you make another timely objection before it, depending upon what is presented.
I will do so.
Okay.
Yeah, of course.
All right. Let's move on to 13. That is the 2/16/2015 aggravated assault, terroristic act shooting at 114 and 156 Monterey. Maury.
That's the
Mike
best.
Oscar, Uniform Romeo Yankee, Avenue, Atlanta, Georgia. Shooting with a rival gang. APD file or report number 150503213.
Your Honor, we have 5 minutes. 2 minutes. A minute 30.
Dang. Yes, it's a negative offer. Yes, you're gonna have 5 minutes. Yes, sir. And the rest of you as well. So.
They put pressure on these niggas, man. Hey, get this shit. Sorry, y'all watching the Cavaliers. Game.
Oh, in chambers. Oh, okay. I thought it was back there.
Doug,
All right, councils.
look at it like that.
All right, Ms. Love, go ahead and if you want to present number 13 that we've already identified for purpose of record.
Yes, Your Honor. So the evidence that the state intends to present as it relates to the listed Act 13 on our November notice has more to do with the fact that the shootings occurred. These are acts that the state alleges were retaliatory acts that were committed by members of a rival gang. So they are not acts that the state is attempting to show either of the defendants currently on trial committed. So our position with respect to that evidence and similar evidence where we're not alleging either of these defendants committed the act is that I don't know that it can be said to prejudice or to substantially or unfairly prejudice the defendant in such a way that substantially outweighs its probative value. The retaliatory shootings committed by people other than YSL provide context for other acts that the state alleges that members of YSL committed. So we would ask that the court not exclude any acts, and we didn't list every act that we intended to show evidence of that we don't allege was committed by one of the defendants. And we will not, of course, we know that any presentation of the evidence is subject to the court's determination of whether or not the evidence is in some way unnecessary or cumulative or any other reason that the court may be proper for the state not to present it. But it's our position as it relates to this particular one and ones like this that neither of the defendants really have any reason or cannot really assert any prejudice through the admission of this evidence. So if the court permits, I'd like to just speak on it once anyone else has had a chance to respond.
All right, let's see if anybody else is. Mr. Steele or Ms. Sharp?
Your Honor, I think I speak for all of us. We don't have any opposition to, now I'm not agreeing to all retaliatory acts
Just this
in
one.
total, but this particular one, we don't have an opposition to that.
February the 16th of 2015.
Correct.
Okay.
And I believe, quite honestly, believe there's a couple others from January 10th involving the same alleged victim, houses associated with him being attacked, and we don't have a problem with those either.
There are other retaliatory shootings, and we will notice.
Let's deal with them before as they come up. Okay. All right. Can we deal with so 13 is no objection. 14 alleges that on 10/27 of 2014, not 15.
Right.
There's an armed robbery, aggravated assault, arrest of Trontavious Stevens, arrested with red bandana in his right pocket, YSL tattoo on the side, Cleveland Avenue ROC crew on his hands, told Detective Mark Belknap that he, Stevens, is a member of ROC Raised on Cleveland, but that they no longer go by that name. Instead, they go by YSL, which first stood for Young Slime Life, but they had since changed that name to Young Successful Life after his friend Jeffrey Williams gained more popularity.
So Judge, this act falls into a similar category as the one that we just discussed. Neither of the defendants currently on trial before your honor are directly implicated as it relates to the crimes that police were investigating allegedly committed by Mr. Stevens. However, since it was not one of the overt acts listed in the indictment, we just wanted to make sure that the defendants were aware that this was evidence the state intended to seek to introduce. Mr. Stevens is a person who has entered a guilty plea, who has signed a proffer, and we do anticipate calling him at trial. I believe that one of the components of the proffer actually addressed directly or indirectly this incident. So, you know, with a proper foundation and all of that, the state does intend to introduce this evidence as proof of a material element of the crimes alleged in this indictment. So I'll stand down until the court permits me to respond to any arguments by defense.
Okay, Mr. Short or Mr. Steele or anyone else?
I do, Your Honor.
Okay, go ahead, Mr. Steele.
So, Your Honor, if Mr. Stevens is truly going to be called and decides to testify as a witness, then obviously he can be, you know, other people may have objections, maybe I have an objection, but I would assume that the court may let in anything about YSL or Rock Crew becoming YSL or something to that effect, and we can cross-examine him.
Well, suitable foundation, yes, sir.
So I just think that's just typical testimony. I would be objecting if it comes from Detective Belknap, because obviously that is Confrontation Clause information. As far as the armed robbery itself and aggravated assault, I would object. I don't know much about it. I'm not saying I did not get it in discovery. I can't place it in my mind right now. But unless that's tied to furthering a purpose for this trial or furthering criminal street gang activity as alleged in this indictment, count one, then it would, I would object to it unless it's being used somehow to impeach Mr. Stevens. And the only way to impeach him on that would be the prior conviction. You don't get into the specifics, but I would take that up as the trial progresses. I'll make objections, but I don't want to concede that part of that notice. If I didn't make myself clear, I apologize, but I'm just saying I probably don't have an objection to the second part of it. I more potentially have an objection to the first part of it. You know, I'm making this up. If Mr. Stevens went out and his girlfriend was with another man and he armed robbed that man and committed aggravated assault on that man, I don't know why that would come into this trial. So that's what I'm saying.
All right, okay, thank you, Mr. Steele. I'm going to admit it subject to foundation and further objection, but it'll be admissible. Assuming the state can lay a proper foundation in regards to, and Mr. Stevens is going to testify.
Thank you, Judge.
Okay? All right, and number 15.
Your Honor?
Yes.
Just clarity, that last ruling is conditioned on Mr. Stevens actually being a witness. Is that true?
Yeah, because, and also maybe potentially Detective Belknap, but depending upon what's elicited or solicited from either one of those two.
No, I understand this Detective Belknap without seeing a tattoo possibly, that's one thing. I understand.
Yeah.
Okay.
All right. And number 15 is the 12/24/2014 aggravated assault. Photographer attempting to take a picture with Jeffrey Williams was shot by a YSL member. Present were Jeffrey Williams and Martinez Arnold, among others.
Yes, Your Honor. So this was an event that happened at Midtown Cinema. No one was arrested. Law enforcement officers responded after calls were made regarding a shooting at the location. They spoke with witnesses who are included on the list of names the state intends to call at trial. I specifically have spoken to the person, one of the two people who was shot, and I intend to call that person. Judge, this is an incident wherein someone attempted to get a picture with Mr. Williams, and Mr. Williams was flanked by other members of YSL. A person who was attempting to get a video of Mr. Williams and the interaction, in fact, captured a still shot of the parties present. Subsequent conversations with law enforcement revealed that the person directly to Mr. Williams's left was the person who fired that shot. And I believe, looking at that, I don't want to misspeak, but I believe that that was Mr. Arnold. I will confirm. However, Your Honor, the point of it all is that these are people who stand ready to act on behalf of Mr. Williams. The photographer in that particular case he did not wield any kind of weapon. There may be an argument that, they were acting to protect Mr. Williams, or maybe defense may claim it was some kind of mutual combat. I don't know, but nevertheless, the state's position is that those are matters that go to the weight, not the admissibility of the act itself. So we would ask that the court allow the state to introduce, if the state so desires, evidence of this particular act occurring on December 24th, 2014.
All right. Mr. Steele? Excuse me.
Your Honor, it's Christmas Day before Christmas. It's December 24th, 2014. This is located at Midtown Cinema. The person shot, one of the persons shot is Mr. Reed, R-E-I-D. I have no reports or statements in discovery by her at all. There was another gentleman named Mr. Grimes, G-R-I-M-E-S. And this cinema is at 931 Monroe Drive. There's a large crowd. Allegedly, Mr. Grimes wanted to take a picture with Mr. Williams. He was warned, allegedly, not to touch Mr. Williams by an unknown person. Mr. Grimes and this unknown person got into an argument where they started pushing and shoving each other, and a firearm was discharged. Nobody says it was Mr. Williams involved at all. Mr. Grimes was shot in the upper thigh, in his left upper thigh. Mr. Grimes stated he did not know who shot him. I did not get this notice until September 26, 2023. It's under 418. There's a notice that's on the state's witness list. That notice is late, as I cited to the court, the cases and the statute.
Have you interviewed this witness?
No, this is somebody I need to interview.
Okay.
In addition to that, there's a video of this incident that law enforcement officers looked at. This is Officer King, King. That night, he reviewed the video of the shooting. It had to be exculpatory for Mr. Williams. Mr. Williams was never arrested, indicted, charged at all. In fact, nobody was arrested, and it appeared that it was some justification. I have never been given that video. That is exculpatory information to allow this in. I've never gotten
Has the
it.
video been provided or does it exist, Ms. Lowe?
Your Honor, I want to be very clear. There's no video that we have or that I'm aware of the Atlanta Police Department has, and Mr. Williams has been on notice and apprised of the circumstances of this incident long before now. Actually, I think in September of 2022, he was provided at least a summary of this incident. I will confirm looking through my records, but certainly before more than 3 or 4 months ago, he was provided that, and we've never been asked for that particular video, and we don't have it in any event. So the fact that there is no video at this time should in no way factor into the court's determination as to whether or not this incident is admissible, but that's for the court to tell us parties. But we do not have a video. I believe that Mercier or King, if Mr. Steele is correct, pulled some footage. I wholly disagree with the notion that it's exculpatory. I understand that Mr. Steele is an advocate for his client, but I disagree with that entirely. And we would just ask that pursuant to and subject to the proper evidentiary foundations being laid, that the state be allowed to tender evidence of this act as well. And to be clear, we are not saying Mr. Williams shot anyone. The witness is not going to say that Mr. Williams shot him. So I don't know why that distinction was made when Mr. Steele stood, but we didn't say that.
Are you going to call Mr. Arnold?
That's not his
call,
picture, by the way. If you wanted help, that's not his photograph.
We're going to call the witnesses who were there.
Or Mr. Grimes?
Right.
Okay, so let's assume that Mr. Grimes testifies about what he testifies to, but how are you going to get into this particular incident involves YSL members?
Yes.
Okay.
And from that, we have law enforcement testimony who were, one, on scene, and two, who aided in the ensuing investigation into the matter itself.
Your Honor, I don't have a video. The video existed. It's in a police report. It was watched by the detective, no arrests made, and it was found to be a justifiable shooting potentially. That's how it reads in the report. In addition to that, I didn't get notice on time.
But Mr. Love's telling you got it in 2022. Plus, here's the other thing.
Where's my notice?
But here's the thing, Mr. Steele. Right, even though you're claiming it's late at this point in time,
Extremely late.
arguably, I'm going to give you some time to kind of look at it. So if you haven't interviewed this witness, I'll certainly allow you to do so. You can put them on the list of folks to given the ban period, the time that the court told you, indicated. And once you've interviewed the witness, then I'll defer ruling on it for the time being. But we can.
What's the purpose, Your Honor? This is not 418 evidence. What's the purpose?
It may be admissible for other things.
What? I'm not trying to be curt, but what is it that Mr. Williams is around people who may have been justified in shooting?
Okay, here's the thing. If other people were going to testify that one YSL members were there, and that
who's going to testify?
I don't know. I mean, that's what she being Miss Love is telling me, that there are going to be other people that will testify that these particular individuals. Do we know who shot the photographer?
No, that's the whole point.
John, we do have the person that is identified. I spoke with law enforcement, and the person identified in the photograph standing to Mr. Williams' direct left is the person that did. And Mr. Steele was being so kind as to correct me as to who that was. But the state has alleged throughout you know, throughout this trial, that people act on behalf of Mr. Williams. They are willing to shoot on behalf of Mr. Williams. And we're just alleging that
Yeah,
this.
so Mr. Steele, I'll defer until you had an opportunity to talk to the witness. And then I'll make a decision at that point in time.
When is it too much for the cup? I mean, this is December 2000.
Okay, Mr. Steele, we've had the same argument. You had made the same assertion over and over again. The state's got to be able to prove their case. You got to defend your case. I understand that, but I'm going to remedy the situation by allowing you to interview the witness. And then if you have any further argument at that point in time, I'll hear at that point in time. So I'm going to defer at this point.
I understand, but I just.
It's the best I can do at this point in time. I understand your concern.
There's no prosecutorial need.
Right.
Their whole claim is
You don't get to prove. You don't get to determine how they prove their case. I mean, that's part of their. There's it's subject to a cumulative objection. The case law, I think, history is pretty replete with examples of the state gets to. Unless it's just overly repetitive or other things.
It is.
But I can't make that decision until evidence is presented. I can't. They've got a lot of stuff to pick and choose from, Mr. Steele. So, to your point, I think that's probably one of the challenges in this case. But until they present this stuff and it gets in, and I kind of look at it and evaluate it in context, I can't make a ruling on it at this point in time, but I'll defer it at least until you get an opportunity to talk to Mr. Grimes, and and of course it's subject to additional foundation. Okay.
I will step back, and I wish everyone a happy holiday. But I will say this, Your Honor. I get discovery late, I get witnesses late, I get the notice late at some point.
Okay, and you've made that argument very, very well, and I'm trying to kind of
y'all playing games.
deal or fashion a remedy that will be fair to all of you. I'm gonna take that up as I see fit. So
they scared they're
that's
going
why I'm going through the exercise I'm going through right now to make sure that you get to talk to these witnesses and perfect any other argument you may have. So I understand that. I'm sensitive to it, but I made my ruling. Okay. Thank you, sir.
Thank you, sir.
All right. So, Ms. Love, if you will prepare a suitable order thus far, saying that I have deferred ruling on the incidents on 5/12/2020, 5/12/2013. I am going to admit, subject to foundation, the incident involving on 9/11/2013, that there is no objection as to the incident involving on 2/16/15, that I'm going to admit the 10/27/2014 incident subject to foundation, and that I'm going to defer ruling on the issue of the 12/24/2014 until the witness is interviewed. And I'm also I'm going to also put in the order that the witness for the 5/12/2013 incident needs to be interviewed as well. All right. And of course, Monday. Yes, Mr. Steele.
I thought the court previously said that not only would we get to witnesses that are upcoming, and both sides have to do that, but also any other recordings, documents subject to, issues that you wanted to take up so we don't waste the jurors' time. I did not get any of that. So if the state could please just send me whatever, or if they agree to what I'm saying, I believe that was your intent and your order. We can have that too. I appreciate the witness list, but it's not going to help us too much when I say, the state's about to put in whatever, I don't know, an exhibit that I've never seen before, or it's inadmissible, and then the court's going to say, I thought you guys took care of this.
We'll have that. We'll have an exhibit list ready for council.
Okay.
Yeah. I'm sorry, Judge.
By what time and date, ma'am?
So
You think we could get to, they could get it this Friday?
Yeah, right.
At least for the people you're gonna call this coming week through Thursday.
Your Honor,
They don't want to
if we
release.
could be permitted to, until Monday, given, the
Wow.
availability of resources, I don't think that we would be tendering anything that there is much contention about. I will
These won't get exposed. Terrible.
review our case as it stands to make sure that I don't think that that's the case. But if the court
Well,
can
it
permit
shouldn't
us
be
until, then that would be most beneficial.
Shouldn't be admitted.
But he's asking for the list, not the. No. And I think that the request is for the list, not the physical evidence.
Whatever,
Yeah,
just to
physical.
make it known, that's my point. If you wanna send me, if it's easier to send the actual document, that's fine. But it is, there is discussed, you know,
Yeah,
just.
Let's just say by Friday, you need to submit, Friday at 5, you need to submit whatever it is identify and either point out in discovery or send them a copy of that you intend to introduce at least for the following dates of 27, 28, 29, or 30 November.
We gotta get that up.
Okay, we good? As to that?
Yes,
All right. Now moving on to the last two items of business, the motion to exclude some screenshots.
We have not had the opportunity to respond to either Mr. Nichols' motions or Mr.
I'm gonna do it orally at this point in time.
You know, we haven't even had the opportunity to view it. Like literally,
I'll tell you what, I'll make it very easy. I'll exclude it.
you know, we're just asking for a time. Like those
Nope.
two pieces of evidence.
I don't have time at this point in time. It was filed at this point in time, so you got to respond to it now. Okay, because I don't have time. We're going to trial on Monday. We're not coming tomorrow. So I'll just have to deal with it the best way I can at this point in time. So I'm not trying to be difficult. I'm just telling you, that's the only other option I have at this point in time.
You just did what you wanted.
We don't have nothing.
If the court would just give us one moment.
Where are the screen grabs and that are the subject of the motion?
Does the court, or will the court permit counsel for defendant to just provide us with a courtesy hard copy as we speak?
If he
not,
has
that's
it,
fine.
yeah, sure.
I don't have a hard copy, Judge. They were in,
Did you file it with your motion that was filed on on November the 15th of 2023?
I don't know, I don't have that. I was not here to argue that. But they came in an email from Ms. Hilton dated Friday, November 3rd, 2023, at 1:47 p.m. So if Ms. Hilton can pull up her email.
All right. Well, let's see if we can find it.
I want you to see it.
Attached to that.
So this is which motion? What's the date that he filed this? The motion that they're talking about. What was filed on the 15th? What was filed on the 3rd? Does it relate to the screenshot?
These just went out. We went out and tried everything they could try to pin these niggas. That's the crazy part.
What day did you about that, November 15th?
I'm sorry.
You got that on November 15th? Would you mind forwarding your copy of it? You said you forwarded.
Sorry.
Your motion.
Yeah, someone said it was like,
She sent you your motion. Okay.
she emailed it to me on 4/24. And maybe it's from Dane.
I have a copy of Mr. Harvey's motion, but I don't have the exhibits with it.
No, I just forwarded the exhibit.
I'm sorry, madam?
I just forwarded the exhibit.
I can't hear you.
I just forwarded the exhibits.
Thank you, Madam President.
Okay.
Your Honor.
Did you send it to me?
No. I'll give it to you, Christina. Done. Sent. Okay.
So, Your Honor.
There seems, can you just share it? I mean, is it on file or whatever? I think I can just, there's, if I'm looking at this correctly, there's 1, 2,
They doing all type of shit.
3, 4, 5, 6, 7, 8. All right, probably less than 15 grabs. You want to share your screen, Matt? Can you put them up and we'll just share, I'll just address them one by one?
Yeah, sure.
All right, okay.
They doing all type of shit.
Okay. So. We can. These are an Instagram story. Okay. So
They gonna mute it.
I mean, my calculator into the Zoom room.
Let me see if,
I'm in.
you have it? Okay, all right.
I probably will need sharing capability.
All right, let's see if,
I'm just asking for sharing capabilities.
you should be able to have it now.
They doing all
Not,
type of shit.
make sure.
All I can say. All I can say is free plug, man. Put a free plug in the comments, man.
Madam, can you give a state sharing
I'll put free plug in
capability?
the comments, man.
Thank you. All right.
And Your Honor, asked that the state, what the state's response was. Whenever the court tells me, I will endeavor to respond.
What's that? I'm sorry.
I think that the court asked prior to us breaking just now. I think that the court asked what the state's response was to Mr. Harvey's motion. Whenever the court tells me it's time, I'll get up and respond.
Okay. I believe that, let's see. Okay, Mr. Harvey, anything you want to argue specifically? I've got your motion, and I'll go ahead and acknowledge that I have seen it. But is there anything in regards to the motion that you'd like to specifically point out?
Well, the only thing that I would, the only thing that I would point out to start with, Judge, is that under 901, the state has the burden of proof as to the authenticity that's on the proffering party, and there's no presumption of authenticity. So the first issue is not my burden, it's on the proffering party.
Yeah, it's foundation.
And I would respectfully reserve my opportunity to respond.
Okay. Is the state going to be able to lay a foundation for the introduction of these particular screen grabs? If you could kind of give me or give me kind of an orientation of the foundation and or their admissibility for what purpose?
So, Your Honor, the state's position at this time is that this is a premature matter that is not yet right for the court's consideration, given that we've not tendered it. We've just provided it as part of discovery. If at the time that during trial we tender the evidence, having laid the proper foundation, I believe that would be the time that the matter is ripe for consideration. As to, you know, what I'm looking at in the motion is they're arguing that we cannot lay a foundation. We cannot prove its authenticity. We cannot do all of these things. Well, those are a lot of assumptions on the part of the defendant. And we don't, at this time, the state doesn't have to tell them, lay it out for them how we're going to prove or how we're going to get this evidence in. If we don't lay the proper foundation, if we don't meet all the requirements for the admission of evidence, then they can object and it doesn't get admitted.
Subject to a proper objection.
They need the right
and so
to
I think that this is
discovery.
this issue is nowhere near right. I don't know if it's an you know, people are vigorously advocating for their clients, so I'm not going to fault anybody for that. But to somehow say that evidence should be excluded because they don't know how we're going to get admitted,
How they gonna prepare?
it just does not rise to the level of ripening the matter such that we can even address it at this time.
All right.
Well,
And we should.
Mr. Harvey, I'm inclined to agree with the state in terms of the foundation, because it's not yet in terms of,
Not
it may
ready.
be subject to some objections that you raised,
Case not
in
ready.
your motion, but until the state lays a foundation, I can't rule upon it yet.
Well, that's my first objection. The second objection, Judge, is let's, for example, look at the first screenshot that they gave us.
I don't know which one you're talking about.
And Your Honor,
Well, the first one that's up there.
as it relates to,
They literally got
Let
bullshit.
me see it. Oh, okay, all right, so.
Yeah, Ocean Drive, South Beach. No date, no time, no number, no nothing. What's the probative value of this?
Don't know yet. Don't know what the state's going to offer it for.
What's the point of having it?
There's,
I mean, look, it might be they introduce a witness that says, "Hey, we went to South Beach, and here's a picture of me and your client." At that point in time, yeah. I mean, so, or if somebody says, it can be used for any number of things, Mr. Harvey, but I can't really determine at this point in time and rule upon an objection until it's offered for a particular purpose that meets an element of proof or foundation's been laid.
it's irrelevant on its face. It's
I
irrelevant on its
need to decide that. I think it's too early for me to decide that right now.
Sure.
All right, well,
And I'm not gonna at this
And
point.
I'm gonna-
So I'll note your objection for the record.
I know you will, because it is on the record.
Understand that.
But it's going to require an out of the presence of the jury hearing
Aaron,
to
to
see
see it.
if a foundation can be laid prior to getting before the jury and trying to do it and talking about each one of these things. What is that? Where did you get, so I'm requesting an out of the presence hearing to see if the
I'm
foundation.
gonna have to wait and see what happens on that, okay? Because, and I'll take, if you prompt me as to that, Mr. Harvey, I will certainly, depending upon it also depends upon what is offered and who is offered. But I'm not gonna take every witness to determine whether or not there's sufficient foundation. I don't have to do that.
I disagree with you.
All right.
Okay, we're gonna have to disagree on that. If it comes to the point where I need to put the jury out for me to consider that, I will. But I don't have to do that for every single witness.
Oh, I don't think you have to do it for every
For
single.
for a predetermined reason. So I have to wait and see how the state presents its evidence, what they present. And like I said, please prompt me at that time. If you think it's that time where, hey, we're gonna get into this issue and Judge, I renew my objection about that, then I'll consider it at that point in time.
And that's fine, I'll be sure to prompt you.
I'm sure you will.
All right.
Okay. All right. So I will defer ruling on that until a foundation is attempted to be laid or is laid in that particular situation. Okay?
thank you, Judge.
All right. Okay.
They played a lot of foo-foo games.
Mr. Matthews, you have a motion limiting on behalf of Mr. Yui in regards to a statement.
Yes, Your Honor.
Do you have a copy of the motion, sir?
I do have a copy of the motion, Your Honor. I just need to get a good email address to send it to Your Honor.
I'm sorry. Can you email it to everybody, please, sir?
Sure.
That'd be wonderful. Thank you. You sent it, Mr. Matthews? I'm just checking.
Is the court waiting a copy of the motion?
Yes.
I can send it.
Yes, I sent it. You should have it, Your Honor.
All right, sir. And, Ms. Love, have you printed the order for me to sign it?
Ms. Lowe.
They were working on that, and I'm just gonna check and make sure they have it.
Well, I'd like to sign it before I leave
Okay, I have,
momentarily.
And Ms. Lowe.
the court just authorizes the first.
Hell, everybody else signs my name stuff, so why not?
Can you send it to everybody else?
These niggas playing games.
It's not populated. That's why she's there.
Niggas farting and shit.
Mr. Matthews, I have it. Thank you very much, sir.
Thank you, Judge.
All right, sir, go right
Yes, Your
ahead.
Honor. I'll be very brief. I'll start with hopefully the easier ones. Number 6, Your Honor, it says in reference to a statement. Well, first, the context. Mr. Marquavius Hewitt gave an interview on November 24th, 2020.
Yes, sir.
And during that Mirandized interview with Detective Henderson, he began to have a conversation with Detective Henderson. And these are the points that I'm bringing to the court's attention to ask the court to determine that and this is in the event that the government decides to use that interview in its case in chief. So in the event they decide to do that, I'm asking the court to consider that in paragraph 6, where Mr. Huey makes the statement that he just paid off a traffic ticket and that his pretrial officer may have been aware of it. I would argue to the court that that particular statement is not germane or intrinsic to any overt act or account in this particular indictment. And because it's not intrinsic, we would argue that in addition to that, it's not relevant, and that it places Mr. Marquavius Hewitt's character into evidence, i.e. he paid off a traffic ticket, and secondarily that his pretrial officer may be aware of it. So to ask the court to determine that that those are not relevant to the indictment.
Let's find out whether or not the state's even gonna offer or evidence of that.
Your Honor, as it relates to the statements made by Mr. Huey, the state's position is that any and all of those statements that are statements which may be perceived arguably as admissions by Mr. Huey, we are not saying that they are the ones that have been identified are necessarily things we want to put in front of the jury. But what we are saying is that they are statements of a party opponent that should the state choose to have them introduced.
What's the traffic ticket and pretrial offer have to do with anything he's charged with?
Your Honor, as it relates to what Mr. Huey.
Because if I understand correctly, hold on. If I understand correctly, Mr. Matthews is saying, he's saying that particular portion of the interview may inadvertently put his character in issue unless it's related to something that you're going to prove.
So, 2 things. One, as they relate to matters like, I received a traffic ticket. That is not the type of act that courts have considered prejudicial to the defendant. He is charged with much more serious crimes. So those types of things that may be interspersed throughout the statement that Mr. Huey gave are not necessarily things that we're even seeking to put before this jury. But more importantly, Your Honor, depending on how cross-examination goes, depending on, what is brought out by Mr. Huey when he puts his questions on the witnesses. Some of this may be relevant, none of it may be relevant. But Your Honor, we don't want to be prematurely precluded from introducing evidence. What we can do and what we will do is at the point where we will seek to introduce it, if we choose to do so, we would ask the court just be giving us a moment and an opportunity the day before to say, hey, this is what we're about to do. And at that point, I think it becomes right. But at this point, I think it is not right for discussion, and it's premature. They are asking the court to exclude the defendant's statements.
No, just the statement, if I understand correctly, Mr. Matthews, about the traffic ticket and reference to his pretrial officer.
That's correct.
It's just that, it's not the other statements?
Well, no, I'm cherry picking right now, Judge, because I'm going through what is easier for the court's determination to more challenging ones in the body of the motion.
And so we haven't even decided yet that we want to even play that statement. So
You don't know whether or not you want to play the statement at all?
No.
Okay.
No,
all
it
right.
just depends on how things go.
All right, let me do this then. Why don't I defer that until if the state decides they want to introduce it, then at that point in time, Ms. Love and Mr. Matthews, I'll revisit the issues of whether or not it's his statements.
Whether or not something is more
Whether
substantial.
or not statements are, if you're not going to introduce them, then I don't have to rule on them.
Right.
If they do, then I'm going to need to make some, you're going to need to tell me what purpose that the statements come in for.
And then, Judge, there are about 4 or 5 other statements within that motion that we will address at that time.
Right,
Well,
and so,
I was just trying to deal with the easier one.
Was he, okay.
so
Was he arrested on this particular item, this particular incident?
Yes.
On 24 November 2020?
Yes, Your Honor.
Are there any overt act, are they related to any overt acts as in the indictment?
Shouldn't be.
Does this 24 November 2020 incident, does it involve any of the overt acts or counts on the indictment?
Yes, Your
indeed
Honor.
it does, Your Honor. The stuff that was found is
Well,
the stuff that was, no, let me explain. The
Okay.
items found in his home are the things from the armed robbery of Chandler Durham.
That's right. Okay.
That's one
I
of the
better
acts.
wait until they lay a foundation, Mr. Matthews. Assuming they can lay a foundation, then I'll take up this issue.
Because we will, yeah.
Because they may be relevant for other reasons. So again, I'll invite you before that comes up, depending upon what's been presented, I'll then re-engage on this issue of the motion in limine. Okay?
That's fine, Your Honor.
Okay.
I don't believe it was an armed robbery of Chandler Durham.
I'm sorry?
I don't think it was an armed robbery of Durham. I think it was a theft by taking of a vehicle.
Okay.
Okay.
All right. Okay, I
Thank
think
you, Your Honor.
You're very welcome, sir. I think at this point in time, have you gotten an order yet, ma'am? Because I think we have exhausted the business for today. So I'd like to sign that order.
Okay.
Yes.
Just pertinent to your last analysis, if, and I don't know what Mr. Huey will do, but if Mr. Huey does not, I'm just using him because of his statement to law enforcement, he does not testify, I'd like to put everybody on notice. I know I've spoken with the prosecutors. There's some issues. It's not a admission by a party opponent as to Mr. Williams because it's a conflict. That's a statutory. That's a
No, but
conflict.
the state has to prove against different people, different things. So it may not be admissible.
But y'all
I
put
am
in,
just
but y'all
asking that
put in
Mr.
plug
Williams,
and
attributable to
shit.
Mr. Williams.
I understand.
But it may be attributable just to Mr. Huey. So to that extent, and then, you all will have to, kind of argue or educate as appropriate at the time that it comes.
Well, I've done this before with court, and you said yes. It's everything like if somebody mentions Mr. Williams, it's excluded. If it's appropriate to be excluded, but What I'm saying is, I will be asking for a jury instruction. So I'll give it to you, the jury instruction I request, but you know.
That's early. You're
That this could not be used against Mr. Williams at contemporaneous with the statement. That's why I brought it up.
That's way down the road. I'll take that up when we get to it, Mr. Steele. Okay. I certainly, when we have charge conference and you submit your charges, depending upon when evidence is presented, I'll then consider it at that point.
Okay, but I'm saying a limited jury instruction before the statement, like.
Now you talk about limiting instruction
Exactly.
in regards to what?
Like, let's say Mr. Huey's interviewed by law enforcement and makes a statement to law enforcement. I can't cross-examine him. That statement is confrontation. So.
But if it doesn't apply to you,
that's what I would.
if it doesn't apply to you, then if it applies to somebody else, why would you want a limiting instruction? Why would I have to give one?
Because that way the jurors know it doesn't apply to me.
But you're going to argue that.
Yeah, but I'd rather have it in court.
No. I mean, unless there's some legal reason for me to do that, Mr. Steele, I think that I'm not inclined at this point in time, not to say I won't do it, but I think it just depends upon what the state offers for what reason.
I think Rule 105.
Try leaving them clueless.
24 dash what?
Whatever it is, 4105. Dash 1.
24 dash what?
And 105 speaks to request for instruction when evidence is admissible against one party and not another party. So I intend to go out to trial, ask the court to use 105 instruction.
Your Honor, I believe that it may not be inappropriate for the court to give a limiting instruction when a statement is being tendered against one party opponent and not the others. So at such time as that circumstance arises, we would not have any objection to an appropriate limiting instruction. We think that that keeps the record and the facts before
That's
the jury.
fine. I mean, but yeah, I understand that. But what I'll do is whoever wishes the court to go ahead and consider a limiting instruction, if you'd please draft it, send it to the other opposing party so I can look at it. And please do it far in advance so I don't want you to say, Judge, this witness is going to be called. I need a limiting instruction. I can't, and I got to pivot. So to the extent you want me to give it, please draft it, send it to Mr. Kearns early enough so I can go ahead and take it up like a couple of days prior, and I can look at it. We can source it. I can edit it, and then it can be given.
It should be flawless because if we're sharing information beforehand, our witnesses and exhibits, reports, et cetera, we would be on notice, the state would be on notice.
I don't have any issue with that, Mr. Steele.
That's what you want.
Yes, I do. That's what I'd like you to do. All right, Mr. Harvey, anything else about that? About the 105 limiting instruction?
Yes, sir. That's exactly right.
All right, so, but please don't do it like right before the witness is supposed to be called. I do need to have it a couple of days so we can go ahead and I can revise it or edit it.
Generic proposed.
That's fine.
105 instruction.
That's fine. Just make sure it's sent to everyone who's in that particular category. Please, draft it so I can go ahead and look at it.
And we get the exhibits so we can do that by 5 o'clock Friday, I can send mine, and then the openings, I should send mine, maybe not out of it, but they definitely get it tomorrow morning, we can go out.
Everybody needs to have opening statements or whatever exhibits you're going to use by Friday at 5. Friday at 5.
Exhibits for opening statements.
Say again? For both, yes. Anything you're going to use in opening statements, PowerPoints, exhibits, need to be tendered to one another by Friday at 5. Friday at 5.
I know Dirk and I'm watching that scared as shit.
Thank you, sir.
Hopefully that motherfucker, man, don't come and
Okay, you
fuck
got that order yet, madam?
Judge,
me.
we were
West
trying to
Savage,
get
all
off
of
of
them.
the
Little
list. I
baby.
don't know if Mr. Steele has had a chance to take off the law enforcement and professional, but we were trying to just restrict it to lay witnesses. And may I inquire of Mr. Steele about that redaction of professional people? Okay. So we were working towards the same end. I was hoping that,
Can you all just look at it now? Come and look at it so we can,
Yes.
so you can just come and look at it so she can delete out whatever it is. I can sign it and it can go.
so the list you gave me had professional people on it too.
That was a mistake. I don't think so, though. I think it was all the way.
No, because he said something. So he was looking at it. He said,
And now it's on a lay witness. I just took your lay witnesses. That's what those
do you want us to give you? Hold on, let me look at it again. Do you have, can you bring your computer over here? Do you know? 'Cause so we have two screens. Okay. 'Cause, what is this? So you're saying
Mine
that
didn't
you
look
took
like that.
this?
Yeah, and I took your witness list and just copied the name
Too many of them.
and date of birth. That was what I sent to you in Word and PDF. Courtney sent it to you in Word and PDF. I mean, you wanted it in structure, and that's why I have these lines, these colors.
Okay, but
Too many
so what I'll do
witnesses.
is say, hey,
All the
here it
scandals.
is, but work on these first, the 70 that you
Yeah,
gave.
I don't really have a problem.
Okay. So
See,
I
they
usually-
not
I would just
releasing
get-
this shit because
I'm gonna get.
all
I'm
the
gonna-
shit was exposed early on.
You don't have to.
That's
break
what
it.
pushed the trial and shit back.
But I just need for y'all to have, so there's no issue, the first 3 weeks worth of stuff. So that if they said we can only give you a piece of it, and then we get ready to call somebody and you say, oh, we didn't get their criminal history because they were down at number 85,000. I don't want there to be an issue, so I need them to at least do the first 70. Okay.
So I don't have an opposition to it.
Okay, this is what I'm gonna do. I'm gonna attach it. That's what I'm gonna do. I'm gonna attach it as a different, but it looks good.
Man, look like street drug. Look at this nigga. Thugger got all these young boys in this case. All these fucking young boys. Like Thugger, he ends up in. Whoever was the leader of the young boys or whatever, y'all tripping. Thugger and Gunner weren't supposed to get caught up in that. Nah. Thing about it is that nigga's been telling on Thugger. Got bad. 2013, 14, and all that. Rich Homie Quan, all y'all niggas. Y'all niggas been listening to his name. But Rich Homie Quan said he wasn't in the lane.
Steele, did you look at the
After they killed
Western
Nut.
State?
Yeah, the order is.
Whoever killed Nut, because he is dead. Whoever killed Nut, he said Thugger wasn't in the lane no more.
The attachment.
That's what made him think it was Thugger that killed him.
Look, and I said, oh, we've covered it.
What, and the other thing, Judge, is that I was just trying to make sure that the first witnesses that are provided for are the ones that we're calling in the first 3 weeks so that no issue arises if they have time constraints that don't allow them to get all of the witnesses to them. So I just want to make sure that the first ones that we are calling, that those histories are provided.
I think you indicated that to me earlier, so.
Okay. I need your organizations.
They don't know what they really
All right,
want to
so
do.
he sent us over the proposed order. I need to get that list off of the proposed order and into some format that works well for this. You know what I'm saying? Let me show
They
you.
got
He
like
just
street
he sent
drop.
us over his
I know
proposed
street
order.
drop, but that's the boy that's
Finally,
locked up for dog
I
food.
did. I changed the orders. That's not an issue. But
You know, all of them with headphones on,
all right,
texting this shit.
this. So look at that and see how he did this right here. This is all that I was trying to change.
Yeah, go pretender.
I'm gonna attach here to as Exhibit A. Okay. See, this is how I did. No, I got it. I know what to do. This is it. Attached here to this Exhibit A. Or, all right, we have it. We're almost here. Persons listed on Exhibit A attached here to shall be subject to that. All persons. Okay, I got it. Okay, all right. I'm going to share this document, Your Honor, with the court and the parties.
Via email?
Yes, Judge.
This shit is crazy. These young boys, man. They fuck their situation up. They had too much access to Thugger, man. Thugger was too accessible, man. Too accessible. Too accessible. That's all I really like to say. Like, it was too accessible.
Did you send it already, Ms. Love?
I had a hiccup and I'm sending now.
Like, it's crazy, man. I wonder is they gonna try to use Gunna. Wonder if they're gonna try. That's the questioning part. That's the questioning part. Is they gonna use it? Is they gonna use his lyrics? Thing about it is they don't know when he wrote the lyrics. It's like the album that he put out. The John Want Me Dead, you could tell it was an old song, like shit like that. It was like, how they really gonna use the lyrics just because it was released the way it was? You know, sound like
Okay,
it was
so what
part
I've
of
done
it.
is send it to everyone. I don't think I sent much in this either, but what I did to remedy the problem of waiting for our reformatting of that was say, the witnesses listed on Exhibit A are subject to the terms of this order. And that way, you can go ahead and get the court signature on the order and attach the exhibit and send it over to legal counsel for the GBI and the GCIC.
Okay, what's on Exhibit A?
It is the witnesses that Mr. Steele has provided, minus things like custodian of records for Magic City or Hertz. Those are names that were listed. I was trying to go through and take that information out. But Exhibit A will consist entirely of the first 70 names that we provided as witnesses we intend to call in the first 3 weeks. And Exhibit A is important because I would like for them to get those criminal histories first.
Mr. Steele, is that agree with, what I want to do is I'll sign the order. You need to, I can print and sign it right now, but you all need to pen and
I think we're in agreement with the people that, the way that we're gonna do it, so.
Mr. Steele, any objection from you, sir?
No,
Is
Your
that
Honor.
acceptable to you?
Correct.
That is passed.
These 2 years ain't playing. They're not playing. Everything they could build, they're
All
trying
right,
to
Ms.
build.
Love, I'm going to hand this to you. Counselors, if you want to check it, or have some, Mr. Steele, if you want to check it, it bears your 2 signatures, that is Ms. Love and Mr. Steele, in regards to the court's signing that order. So you're going to attach Exhibit A to it?
Yes, and this
And when are
way,
you, when are you going to scan that to counsel? You can file it. You can email it to whoever it is your point of contact, but I'd like you to file an order under seal.
that was what I was getting at. I had
Okay.
to prepare that. And
Just make sure that sure that's Mr. Steele, but when are you planning on sending that to counsel for the GBI?
I'll email it before noon tomorrow, probably tonight.
can you send the court a copy and the parties a copy when that is done?
Absolutely.
Will that be sufficient, Mr. Steele?
Correct.
What about anybody else? Is there anybody else who has any specific objection or concern or comment about that? Or is everyone in concurrence that would be a suitable resolution or plan for the GCICs and that we discussed earlier?
And so that council knows, I have included in the order that counsel for defendants currently on trial before this court are permitted to review and share, but only people who are currently on trial
Okay.
for this court.
Yes, I anticipate getting the GCICs and then dispatching it via email to the lawyers here.
Okay. All right. Okay. Unless there's anything else, I'll see everybody on Monday, the 27th. We need to be here
8 o'clock.
and seated and ready to go so that we don't have to wait on our jurors to come. So make sure you're here about 8:30 or thereabouts and get situated and get settled. And we'll get everything started at that point in time for 9 o'clock. As soon as all of our 18 jurors are accounted for, we'll get started. All right.
You did say 9:30 though.
No, I said 8:30. You need to be here. We're starting at 9.
I heard it was 9:30.
Starting at 9, sir.
Just my approach before the court leaves that unrelated to.
Okay. All right. Unless there's anything else, happy Thanksgiving, everybody. Okay. Okay. All right. We're in recess.
What's your look? What y'all think gonna happen, man? That's the crazy part. Thugger, man. Thugger, man. Gotta get it together, man. I hope and pray, man. Everything work in your favor, man. You get back to your kids and shit, man. But if not, man, I pray. You know, man, this shit wake you up. You come home and change some lives, man. 25 years or whatever, man. This is a crazy situation. That's all I can say. It's a serious situation. And like, I won't want to see nobody in this joint. See, they putting this shit on the news for everybody to see this shit. That's the thing. They put everything in there. They put everything on the joint so motherfuckers can see that shit. That's what they did. That's what they did. We're gonna go to Honeycomb Brady. Yeah, Fair Use Act. YouTube. They covered under the Fair Use Act. Honeycomb Brazy. Mm-hmm. He said, bitch, I'm moon. Honeycomb Brazy. It was ugly as shit. Yeah, like Gucci. Mm-hmm. Rest in peace to his grand folks, man. He said he gonna do a song for him, man. But rest in peace to his grand folks, man. Oh. He wants finesse to get that money up. He coming at finesse, man. You do some sucker shit. Uh-huh. Damn. Mm-hmm. 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 He said that nigga finesse ain't got a BBL. Listen, they said finesse got a BBL. Listen, finesse, man. We need some answers, man. We need some answers, man. Woo! Got a hell, he do. Mm-hmm. He said he passed out turkeys in his ass. But nice ass time. Mhm. He said that one yeah. No. Crazy. He was scared from that dog shit. There's only oh, you did finesse. You gotta get that man. You gotta get that man his bread, Ness. J Prince, buddy, y'all. Real shit. Finesse know he owe that nigga paper. Last time about they went to jail. Wait until I went to jail, then start dissing. Who you talking about? Money back? Like, who the fuck? Finesse out there with his ass out. Pass out turkey with his ass out. Listen, man. Finesse, man. You out of order. You out of order. You out of order. Come on, Finesse, y'all. Finesse is out of pocket, man. Finesse is out of pocket. We're gonna go ahead and go to outside camera real quick, y'all. Wait, tripping. Wanted to check on that, man, but I ain't gonna do that, man. I ain't gonna do all that, man. Listen, man. Make sure you like, share, and subscribe, man, to the channel. You know, I'll be back tomorrow. I'll be back Monday too for the, YSL Real Trial Day 1. But make sure you like, share, and subscribe. Free thugger, man. Be safe out there. Holla at y'all. I'm gone.